as an anti-black racist killing. Note that African American community in the United States of America has been under racist attacks by the policing system, which continues to treat them as sub-citizens without full protection of the law. Further note, black people under the U.S. criminal system, purely because of the color of their skin, are permanent crime suspects whom the police harass and kill with impunity. Condemns the U.S. law enforcement for failing to protect its citizens, in particular African Americans, because of the color of their skin. Reaffirms the call for the unconditional removal of apartheid and colonial statues because, like the South African apartheid flag, which the killer was wearing, they continue to inspire white supremacy. Call for all statues celebrating colonialist and apartheid leaders be removed by the end of July 2015, because these symbols provide the basis for white people everywhere in the world to continue to think that they are superior and untouchable. I so move.
That motion, unfortunately, was not circulated. This is the list I have. It's not there. And maybe I should be advised if there was something that happened, because the agreement on these documents I have is that the motion should be circulated by midday.
Honorable Chairperson, we have circulated all our motions today, including the Charleston shooting motion. We have circulated. Please, can the table staff get their act, because we have circulated.
Oh, this is becoming worse. I am told by the table staff that they received not even one motion from the EFF.
Honorable Chair, we have circulated. We can demonstrate it. We have circulated all our motions.
Can we be honest, people, so that we move on?
We have circulated, Honorable Chairperson. Can other whips please attest to us, because we have circulated these motions. All of them.
I would like the table staff to go and check and inform me, because according to this document, there is no motion that was circulated from the EFF. But as they are checking on that, I will allow the EFF to read their motions, although I will use the same principle and not put the question. Thank you. The next person to raise a motion is the DA. Okay.
House Chairperson, on behalf of the Democratic Alliance, I hereby move without notice that this House notes that yesterday, 22nd June 2015, a suicide bomber attacked the Afghan parliament in Kabul while the House was in sitting. Also notes that as members of the House were frantically running for safety, several gunmen opened fire on the parliamentary building. Further notes that a spokesperson of the Taliban, Zabihullah Mujahid, was quick to claim responsibility for the vicious attack. Acknowledges that reports suggest that at least 19 people were severely injured in the attack. Vehemently condemns any and all forms of terrorism, violence, and barbaric attacks on any innocent person or institution of democracy. Conveys our sincere condolences and message of unwavering support during this difficult time to the Speaker of the Afghan Parliament, Mr. Mohammed Yunus Qanuni.
The DA has moved a motion. Are there any objections? No objections agreed to. Next is the ANC.
Thank you, Madam Chairperson. I move on behalf of the ANC that the House notes with great shock the killing of 9 people by a white gunman at the historic African American church in Charleston, South Carolina, in the United States, on Wednesday, the 17th June, 2015. 2. Further notes that the fatal attack in the church in Charleston, South Carolina, is characterized as hate crime, which United States Department of Justice defines as the violence of intolerance and bigotry intended to hurt and intimidate someone because of their race, ethnicity, national origin, religion, sexual orientation, or disability. 3. Recalls that the shooting is the reminder of the 1963 bombing of an African American church in Birmingham, Alabama, that killed 4 girls and galvanized the civil rights movement of the 1960s. 4. Further recalls that the attack also follows the April shooting of an unarmed black man in the neighboring North Charleston by the white police officer, and one of the number of deaths of unarmed black men in encounters with the police that have raised racial tensions in the United States. 5. Believes that hate crime should be condemned by all people of the world and should in unison unite in an action to combat this crime beyond communities under the threat of this crime. 6. Commends United States law enforcement agencies for swiftly apprehending the suspect who did this horrendous crime and bring him to book. And 7. Convey condolences to the families of the deceased, the people of South Carolina, and the United States. I thank you.
Thank you. I now put the motion. Are there any objections? No objections. Agreed to. UDM?
Thank you, Chairperson. I move without notice on behalf of United Democratic Movement that the House notes that 2 Mpumalanga siblings who were trafficked to Malawi more than a year ago are expected to be reunited with their grandmother this week, ending their terrible ordeal. Further notes that the siblings, an aged girl of 14 and her brother aged 20, were taken from their home in Komatipoort in July last year by a woman posing as a teacher who promised them a better education and a better life in the United Kingdom. Commends the Interpol and the specialist team from the Department of Social Development, International Social Services, for their efforts in bringing the children back home. And lastly, condemn human trafficking as innocent children are being physically abused and exploited. I so move.
Thank you. Do you have any objection to the motion? None. The motion is agreed to. IFP?
Thank you, Honourable Chairperson. I hereby move on behalf of the IFP that the House recognizes that Sunday, 21st June 2015, marked the first International Day of Yoga, acknowledges that United Nations declared June 21 the International Day of Yoga after adopting a resolution proposed by the Government of India, further acknowledges that yoga is a compendium of postures aimed at providing practitioners with the substantive benefits of health, fitness and peace of mind, applauds the fine example and leadership set by Prince Mangosuthu Buthelezi MP, Mr. Loganathan Naidu, Speaker of eThekwini, and many other leaders in acknowledging the importance and benefits of a healthy body and healthy mind, and for participating in one of this worldwide events, mass yoga sessions, which was held at North Beach in Durban, and calls upon all members of Parliament, party and support staff to engage and participate in exercise and health-related activities in the interest of being better able to serve the people of South Africa. I so move.
I put the motion. Any objection? No objections. Agreed to. GA?
Honorable Chair, before we proceed, I'm hoping that there's been a correction about the earlier misunderstanding, so that then procedurally our motion can be put as the House dictates.
I was just waiting for the report. No, thank you, honorable members. I got the reports on the circulation of motions, and the understanding is that they were sent to a staff member, and actually it should be sent to different parties. But now the advice is that to allow the smooth sailing of the House, I will put them to the motion, and please rectify that mistake. All parties, it's not only the EFF, all parties have made a mistake. Thank you very much. Thank you.
Point of order.
Yes.
House Chair, then you're going to have to give the NFP an opportunity to put
Yes,
their
I will
motion
do
again.
that. I will do that. All those that I did not put to the House, I will do that.
House Chair, we'll have to hear those motions again because of thinking they weren't going through. We didn't necessarily object. Thank you.
I will do that. I will do that. Honorable Singh?
And House Chairperson, we trust that this is an exception rather than the rule.
Yes,
Thank
of
you.
course it is. Of course it is. Can I allow? I was calling for the DA. We just did the motion from the DA, and I put it to the House. Yes, I did. The next one is the EFF.
Thank you, House Chairperson. I rise on behalf of the Economic Freedom Fighters to move without notice that the House notes that Economic Freedom Fighters in the Eastern Cape is intensifying its efforts to ensure that this revolutionary movement is grounded and is driven by the will of the people. Further notes that over the past weekend, the EFF held the Regional People's Assemblies in 4 regions at Buffalo, attended by hundreds of elected branch members who went on to elect regional leaders who will ensure further growth development of the EFF. Further acknowledge that there is no force alive today that can stop this incoming revolution in the Eastern Cape, as the EFF will be launching 2 further regions in Ixaqadu and Amatole region, which will be followed by a provincial people's assembly that will elect a leadership collectively that will take over the reins of power from the ANC in the next provincial and national elections. Further acknowledge that the people of Eastern Cape finally have alternative that will free from the tentacles.
Honorable Maxson, can we allow the Honorable Ollis to make the order?
Chairperson, on a point of order, can you please clarify, are we now doing statements? Because that clearly is a statement.
This is not a statement. This is a motion without notice. Let me just conclude, Chair. Further acknowledge that the people of Eastern Cape finally have an alternative that will free them from the tentacles of ANC corruption and marginalization, as the new regional leaders will ensure that corrupt mayors, such as Zukiswa Ncitha of the Buffalo City, who was removed quietly by the ANC, whereby a tender box was a source of conflict between the mayor and the MM. Congratulates the new leadership of the Buffalo City and our Tambo region, wishes the Ixaqadu and Amatole region very successful launches. Further congratulates the visionary leadership of the CIC, Julius Malema, who has worked tirelessly to inspire hundreds of thousands of people who had lost hope to find a reason to hope for a better tomorrow that will be ushered by the EFF. I so move.
Of order.
Honorable.
On a point of order, Chairperson, that is not a motion. A motion is a matter for debate. That is a long statement about a party's program of action.
Chairperson, just quickly to address you that in the Chief Whips Forum, we agreed in principle that there is no member of parliament who is going to try to edit the contents of our motions without notice.
Thank you.
If they object to that, they can stand up and object to that particular process.
Point
so
made.
The disruptions of this gentleman...
No, Honorable Mshibambo, your point is made. Please sit. Honorable Ollis, these are motions without notice. So allow the parties to make motions without notice. Thank you very much. I now put the
point
question.
Point of order, Chair. Point of order. I'm here. Here. ANC. Chairperson, That point of order remains a point of order because this is not a motion. This is a statement. If we have to then also do the same and make statements not according to the rules, let us also know that's how we're supposed to operate. That is not a motion.
Honorable members,
Honorable Chair.
before you come in, thank you, Honorable.
No, just before you make a ruling, Chair. You have made a ruling on this matter. And they are supposed to be the people who help you to run this house. And she comes and challenges you, setting a precedent which she will not sustain.
Thank you.
So I think that we must go with the order, the ruling you have made, and ignore what she just said. Please.
Thank you very much. Honorable members, I think maybe there is a problem in us understanding the statements from the notice of motions without notice. And that is not a problem we can solve now in this house because we cannot start with a workshop of that. So I'm going to allow motions without notice. But let's bear in mind that the notice, a motion without notice cannot be that long like a statement that is being made in the House. That's the only thing that I can say at this stage. Honorable Chief Whip.
Honorable House Chair, we object to that statement.
Thank you very much. The motion falls off. The next is ANC.
Honorable House Chair, I move on behalf of the ANC that the House notes with sadness the death of a Constable Silo Mashete, a member of the Special Protection Unit, who was shot and killed during a robbery in Gauteng on Friday, 19th June 2015. Further notes that 36-year-old Mashete, a member of the Police VIP Protection Unit, assigned to protect Minister Pravin Gordhan, was shot multiple times while sitting in his unmarked police vehicle in Stengwater near Hammerskraal. Acknowledges that Mashete's service pistol was stolen and his Toyota Corolla was taken but recovered a few kilometers away. Remember that he joined the police in July 2005 and had worked for the minister since June last year. Recognizing that he was a diligent officer who understood his responsibilities as a protector and knew how to link them with his orders. Believes that the killing of the policemen in general is robbing the citizens of South Africa in getting the services that they deserve, and conveys the deepest condolences to Mashete's wife, Gloria, and 2 young sons, as well as all the family members and friends of Silo. Calls on the police officers not to rest and to pull all stops until those criminals are caught and put behind bars. I so much.
Thank you. Are there objections to the motion? No objections. Agreed to. ACDP.
House Chairperson, I move without notice that the House notes with great concern reports about the mass exodus of teachers who resign early from the profession. Further notes that the Government Pensions Administration Agency revealed that last year 4,600 teachers resigned from the service and almost 1,000 of them from Gauteng. Further notes that the most common reasons for their resignations are poor working conditions and low salaries that leave many teachers with serious financial difficulties. Recognizes the resignations have resulted in a nationwide shortage of teachers, particularly in mathematics and science. Notes that the 2014 Basic Education Annual Report revealed that the number of teachers entering the profession was declining. In 2013, 8,227 teachers were absorbed, and in 2014, the number dropped to 6,762. Therefore, supports the call by Gauteng Education MEC to review teacher salaries and intensify programs aiming at celebrating the positive contributions of teachers to strengthen the profile of the teaching profession. So move.
Thank you. I put the question. Are there any objections? No objections. Agreed to. UDM? UDM? Oh.
I move without notice on behalf of the United Democratic Movement that the House notes that 5 people were killed and the other 2 seriously injured after 2 cars collided in Polokwane on Friday morning, the 19th of June. Further notes that the accident took place at the corners of Tabombeki and Landros Mare streets. Though it is not clear as to what happened, but it is assumed that one of the cars might have ignored a red traffic light whilst the other car was crossing. Further condemns negligent drivers who do not obey the rules of the road. Further calls on the Department of Transport to act tough on drivers who neglect the rules of the road. I so move.
Thank you. Any objections to the motion? None. Agreed to. NFP.
Thank you, Honorable Chairperson. On behalf of the NFP, I move without notice that this House notes that the Durban Magistrate Court convicted a Durban drug lord, Mr. Jen Cheku Chikubu, on various charges of racketeering, money laundering, and dealing with cocaine and ecstasy. Also notes that Nigerian-born Mr. Chimbu was sentenced to a total of 70 years in prison, but that his sentence will run concurrently and effectively means that will be in prison for 25 years. Further notes that Mr. Chimbu's South African wife, who is an accomplice, is on the run and evading arrest. Finally, note that this arrest and conviction was the outcome of sterling work done by the National Drug Task Team of Lieutenant General Vinesh Manu and investigating officer Luke Tancred. Wherefore, we call upon this House to express its appreciation for the heavy sentence imposed by court in the hope that such sentences will act as a deterrent to drug dealers and runners. Convey its congratulations to the National Drug Task Team for their sterling effort to combat the untold misery caused by drugs in our communities all over the country. I so move.
Thank you. I now put the question. Any objection to the motion? No objection. Agreed to. ANC.
Honorable Chair, on behalf of the ANC, we move that this House notes that South Africa's soccer team, Bafana Bafana, beat Mauritius 3-0 during the African Nations Champion qualifier at Dobsonville Stadium on Saturday, the 20th of June 2015. Acknowledges that the Bafana Bafana coach and SAFA had to scramble to get players for this match after several Premier Soccer League sides withdrew their players for the pre-season preparations. Recognizes that Bafana came into this tie on the back of a 2-1 win over Angola in an international friendly at the Cape Town Stadium. Believes that the South African team is highly motivated by the 2 recent wins against Angola and Mauritius, and congratulates Bafana Bafana on this deserving victory and wish them well in their next encounter. I so move. Thank you.
Thank you. Are there any objections to the motion? None. Motion agreed to. NFP. Iman Shah.
Thank you, Honorable Chair. On behalf of the National Freedom Party, I move without notice that this Honorable House notes that on the evening of the 17th of June 2015, a lone gunman opened fire on worshippers in the Emmanuel African Methodist Church in Charleston, South Carolina, a state of the United States of America. Further notes that the church is one of the United States' oldest black churches and has long been a site for community organization around civil rights. Further notes that 9 people were killed, including the senior pastor, Clementa C. Pinckney, who was also a state senator. Also notes that the suspect, 21-year-old Dylan Roof, has been arrested. Finally notes that the United States Department of Justice is investigating the possibility that the shooting was a racial-inspired hate crime. Wherefore, we call upon this Honorable House to convey its condolences to the grieving families of the people in Charleston who were gunned down in cold blood, and convey its condolences to the government of the United States of America on the loss of a senator. I so move.
Thank you. Are there any objections to the motion? No objections. Agreed to. IFP.
Thank you very much, Honourable House Chairperson. I hereby move, on behalf of the Inkatha Freedom Party, without notice, that this House notes that reports of bullying at South African schools are on the rise, with more parents and pupils reporting incidences of bullying. Further notes that a Gauteng learner was recently violently beaten by another pupil in front of his teacher. Acknowledges that in 2013, a survey by the consumer insights company Pondering Panda found that 36% of South African school pupils describe bullying as one of the biggest problems at school. Further acknowledges that being bullied at school leaves a lasting mark on a young person's body and mind. Calls on teachers and pupils or principals to do more to ensure that every South African child is able to receive his or her education in a safe environment. And further calls upon the Department of Education to put in place mechanisms to deal with bullying at school, for example, by including an anti-bullying course as part of our life orientation subjects. I so move.
Thank you. And is there objection for the motion? No objection. Agreed to. UDM, you're the last hand indicated.
House Chair. Thank you very much. Besicela uphinda manathi isenokwenzeka umhlamba uprof Khobiso ufuna object akuthiwa motion yethu sifuna uyiphinda nathi bayive kakuhle abantu umhlamba bazivanga. Since kuphinda.
No, yakho azange ilahlwe baba, hlala phansi. Ichubekile yaqeda umsebenzi wayo. DA.
Thanks, Chairperson. On behalf of the DA, I hereby move that this House notes that South African tennis player Kevin Anderson made our country proud by reaching the Queen's Club final on Sunday. Also notes that Anderson faced third-seeded British resident Andy Murray in the grand final. Acknowledges that Anderson's exceptional performance during the season has taken his international rankings to 14th in the world. Further acknowledges his role in encouraging young South Africans to play the sport and promoting the sport throughout the country. Congratulates Kevin Anderson for his remarkable achievement and wishes him well as he prepares to take on the world. I so move.
Thank you. Are there any objection to the motion? No objection. Agreed to. UDM, Mamachek.
Thank you, Chairperson. I move without notice on behalf of the United Democratic Movement that the House notes that Ngowa Primary School, a school situated in the Eastern Cape in Pedi, has 3 blocks of classrooms that have not been finished over the past 9 months due to builder's contract termination. Further notes that the reasons why the contract has been terminated are not very clear. The school starts from grade R to grade 7 and serves 4 surrounding villages in a 1 old block of classrooms. Acknowledges that the Eastern Cape province has not been doing very well over the past few years in matric results. Maybe this could be because of the poor performance could be attributed to a lack of adequate school infrastructure at primary level. And lastly, calls on the Department of Education to investigate the matter because the right to basic education is compromised. I so move.
Thank you. Are there any objections to the motion?
Thank you. The ANC objects to this motion.
Objection, then the motion falls off. DA?
Thank you, Chairperson. On behalf of the Democratic Alliance, I hereby move without notice that this House notes that World Refugee Day was celebrated this past Saturday, 20 June 2015, as an important date on the International Human Rights calendar. Also note that World Refugee Day was recognized as such by the United Nations in the year 2000 after Africa Refugee Day was celebrated by many African countries for a number of years on 20 June each year. Acknowledges that according to the Refugee Commission of the United Nations, 50 million people worldwide live as refugees, of which more than 15 million live as refugees in Africa. Further acknowledges that approximately 2.5 million of these African refugees are of Sudanese origin. Finally, expresses its solidarity with refugees all over the world and associates itself with the words of the Secretary General of the United Nations, Ban Ki-moon, who said on this last Refugee Day, refugees are people like anyone else, like you and me. They led ordinary lives before becoming displaced, and their biggest dream is to be able to live normally again. On this World Refugee Day, let us recall our common humanity, celebrate tolerance and diversity, and open our hearts to refugees everywhere. I so move.
Thank you. Are there any objections to the motion? No objections, agreed to. Without an indication of any hand, I will go back to the NFP motion, which you... No, the one that we discussed often, it was not put, the question was not put on. The first one. Please, can you read that motion again? Oh, you have done that already? Okay, then thank you very much. Then we have come to the end of the motions without notice. I will now go to the first item on the order paper, and the motion is in the name of the Chief Whip of the Majority Party. Honorable Chief Whip.
Honorable House Chair, I move that the House notes that in the establishment of the SADC Parliamentary Forum in September 1997, the SADC Summit of Heads of State and Government envisaged continuing a parliamentary consultative assembly, its ultimate goal being the establishment of a regional parliamentary framework for dialogue on issues of regional interest and concern. Further notes that a meeting of the SADC Parliamentary Forum will take place in Durban, KwaZulu-Natal on the 5th to the 11th of July 2015. Also notes that SADC speakers recently met with the President Ian Khama of Botswana, incoming chairperson of SADC, to engage him on the transformation of SADC PF into a regional parliament. Acknowledges that the SADC PF continues to operate as a regional parliamentary body that is widely accepted and consulted, not only regionally, but also on the rest of the continent and international. Recognizes the efforts of the SADC PF in improving the capacity of the number of parliaments, particularly in the areas of election observation and management, as well as advancement of gender equality in the region. Further acknowledges that the SADC PF, though not yet formally transformed into a regional parliament, as originally envisaged, has made great strides towards achieving this objective, among others, in its format by operating in accordance with agreed rules of procedure and practice at its most recent plenary assemblies in Mauritius and at Victoria Falls, and express its support for the transformation of the SADC PF into a regional parliament and the lobbying efforts of the leadership of the forum to present to the SADC heads of state and government, Council of Ministers, and SADC Secretariat the case for such transformation that will inter alia A, facilitate the effective implementation of SADC policies and projects, including SADC protocols and other legal instruments, promote the principles of human rights, gender equality, and democracy within the region. First, encourage good governance, transparency, and accountability in the region and in the operation of SADC institutions. Facilitate the ratification and harmonization of policies and laws while recognizing sovereignty of member states, and provide a forum for discussion on matters of common interest to SADC countries. I so move.
Thank you. I now put the motion. Are there any objections? No objections, agreed to. I now will ask the Secretary to read the first order of the day.
Second reading debate, Maintenance Amendment Bill.
I will now recognize the Honorable Deputy Minister Honorable Jeffries.
Madam Chairperson, maintenance, especially child maintenance, is one of the major priorities of the Department of Justice and Constitutional Development. And this is evidenced by the number of initiatives that the Department continues to undertake in order to improve the maintenance system. And just to mention a few of those initiatives, we've launched a turnaround strategy in all the 9 provinces aimed at reducing the turnaround times in the maintenance system in order to improve the pre-order maintenance services, and this ensures that the maintenance system is faster, more accessible and effective. We've also introduced an electronic funds transfer system, or EFT payments, and the total amount of money transferred to beneficiaries in the last financial year was 162,663,925, and it was to 2,265,096 beneficiaries. We've also introduced a direct payment system where beneficiaries want it. And we are also instituting an integrated case management system in 208 courts in the country to provide for the automation and tracking of business processes to ensure speedy delivery of maintenance services. The bill that there's a longer-term revision of the Maintenance Act being conducted by the South African Law Reform Commission, and the bill which is before the House for the second reading is an interim measure of some amendments to improve the system of maintenance, and just to highlight a few of them. Firstly, a beneficiary will be able to claim maintenance where they work, not only where they live, which is the current situation. So it will make it easier for beneficiaries to go to the maintenance court during work hours. If the maintenance, the person that the maintenance is sought from can't be traced, the court can grant an order directing the electronic communication service providers or cell phone service providers to give the court the contact information of the person who may be affected by an order of maintenance. And this direction may only be used if the court is satisfied that all reasonable efforts to locate the person in question have failed. Then there's a duty being put into the bill on maintenance courts to complete their inquiries as speedily as possible. And what's of particular importance is that there's provision for interim orders for maintenance pending the finalization of the matter. And a further provision is that the views of the person who has to pay maintenance must be, or is obliged to make payments, must be sought. And then a major one which received quite a bit of publicity was that if a person is in default of paying maintenance, if they've defaulted, their personal details must be submitted to a credit bureau, and this effectively prevents maintenance defaulters from continuing to receive credit while they owe maintenance. And this, we believe, sends out a clear message to maintenance defaulters that their failure to support their dependents is indefensible. So hopefully the House will support the bill, and I thank you, Madam Chair.
Thank you, Honorable Jeffries. Honorable Muteka.
Honorable House Chairperson, I rise on behalf of the African National Congress to support the bill and want to say that our committee unanimously accepted the bill, but had very interesting discussions, especially with regard to whether or not defaulters should be blacklisted. There was a view that blacklisting would limit the credit worthiness of the defaulters and therefore further disable them to pay their maintenance. But as a result, to investigate other options to blacklisting. And when we considered the alternatives, we found that there is no viable alternative. And therefore, we unanimously agreed that that blacklisting should continue. Of course, other people prematurely attempted to mount a campaign, and that campaign was fruitless because the matter was still before the committee for deliberation. And
order, honorable members.
And we are therefore calling on members of committees to engage inside committees rather than in the streets, because Parliament is their platform to do parliamentary work, and they must leave extra parliamentary work to extra parliamentary organization. Another interesting point for discussion was whether or not complainants should pay for to pay the service providers for providing information to the courts. And the view was that if we accept that position, it would mean that the poorest of the poor, who are women, would not be able to access these services. Therefore, it was agreed finally that in such cases where persons cannot afford, that the state should actually pay and recover the costs from the defaulters themselves. So we think, therefore, that the department did the best in these circumstances, and therefore the presentations, submissions also made by the public were given full hearing, and therefore, Honorable Chairperson, we support the piece of legislation which we have no doubt enjoys the approval of the people of South Africa as a whole, and therefore we unreservedly, as the African National Congress, support the bill. Thank you very much.
Honorable members, before we call on Honorable Horn, I wish to acknowledge the presence in the gallery of the Kenyan Parliamentary Service Commission Committee on Information and Public Communication Delegation. I welcome you to our parliament. Thank you very much, honorable members. Honorable Horn.
Dankie voorsitter. Die meeste jong mense van Suid-Afrika het heelwat stylbulte om uit te klim ten einde hul potensiaal te ontsluit. Ongelukkig is een van hierdie bulte die feit dat 2 uit elke 3 kinders in Suid-Afrika in 'n huis bly saam met slegs een van hulle ouers. Op een of ander stadium gaan hierdie kinders en ouers staat maak waarskynlik op die funksionaliteit van ons land se onderhoudsstelsel ten einde die nodige bydrae vir die onderhoud uit die ouer te kry by wie die kind normaalweg nie woon nie. As agtergrond tot die konsep wysigingswetgewing, voorsitter, moet ons vir mekaar die volgende oor enige onderhoudsstelsel sê. Eerstens, geen onderhoudsstelsel in die wêreld kan suksesvol wees as die houding en gedrag van ouers teenoor die onderhoud van hulle kinders nie reg is nie. In Suid-Afrika is daar ongelukkige probleem hiermee. Solank as wat daar sommige ouers is wie, wanneer hulle verhouding skibreek ly, nie die regte houding en gedrag het teenoor hulle kinders en hulle verantwoordelikheid teenoor hulle kinders nie, en glo dat die verantwoordelikheid van die ander ouer by wie die kinders bly groter is, sal die onderhoudssysteem sukkel om aan kinders die nodige sekuriteit te bied. Daarom behoort een van die doelwitte van regeringsprogramme soos die morele herlewingsprogram te wees om 'n houdingsverandering te bewerkstellig in terme waarvan die eerste prioriteite van ouers wie se verhoudings verbrokkel moet wees om 'n werkbare ooreenkoms te sluit waartoe beide ouers hulle onherroepelik verbind en wat eerstens en primêr gefokus is op die beste belang van hul kinders. Want voorsitter, uiteindelik is dit 'n droom wat ons almal behoort te deel. 'n Droom van 'n samelewing waar ouers te alle koste en te alle tye hulle verpligtinge teenoor hulle kinders nakom. Tweedens, voorsitter, die sukses of mislukking van enige onderhoudssysteem hang naast die wetlike raamwerk ook af van die implementering van die sisteem. Op hierdie gebied is dit ongelukkig so dat daar ook heelwat leemtes in Suid-Afrika is. Enige van u wat al die moeite gedoen het om met diegene in die rye by onderhoudshowe regoor Suid-Afrika te gesels, sal weet van klagtes van lang wagtye, sake wat gedurig uitgestel word en maande neem om afgehandel te word. Laat ons dit duidelik stel. Ons het volle begrip vir die uitdagings wat die departement in die gesig staar. Ons is bewus van die feit dat die departement oor die vorige 4 jaar 247 addisionele aanstellings in onderhoudsverwante poste gemaak het. Die feit dat daar kwartaalliks 44,000 nuwe onderhoudsklagtes by ons howe geregistreer word, illustreer baie mooi dat daar altyd groter wordende druk op die stelsel is. En natuurlik is daar baie onderhoudsbeamptes en landroste wat met ywer en toesig diens doen en die stelsel van dag tot dag maak werk. Maar ongelukkig is daar net te veel Suid-Afrikaners met ontevrede verhale oor die onderhoudsstelsel wat getuig van amptenary wat nie toewyding het nie, swak tydsbestuur by onderhoudshowe en administratiewe rompslomp. Daarom ten spyte van die omdraaistrategie van die departement is wat nodig is uiteindelik 'n stelsel van kwaliteitbeheer ten aansien van die amptenary. Chairperson, in turning to the bill under discussion, the trap may be to lose focus of the very real impact it will have on the lives of ordinary South Africans. Over the last months, I've been in contact with many parents who are struggling to get joy from the maintenance system. The good news is that the provisions of this bill may assist some of them. Mrs. A, for example, is a mother of 3. The father of her children owns a fleet of 5 taxis and is now in arrears to the total of 9 months' worth of maintenance payments because he all of a sudden cut her maintenance in half, apparently because he chose to save for a deposit to replace one of his taxis, rather than pay his monthly maintenance installments. Mrs. B has been able to track down the father of her 2 children for more than a year. His family is unwilling to assist her and has only told her that he apparently now is working at a mine somewhere in Gauteng. He has blocked all calls from her cell phone to his. Chairperson, the good news is that the bill under discussion, once it becomes law, could maybe assist both Mrs. A and Mrs. B. Mrs. A could be assisted in that this bill will enable the so-called blacklisting of her former husband with credit bureaus and prevent him from taking up the credit to buy the 5th taxi before he maintains his children. This bill, once it becomes law, could assist also Mrs. B in that she will be able to apply to one of the different cellular networks to obtain the newest address of the father of her children, thereby enabling the processing of her maintenance complaint. We are, as the DA, obviously very proud of the retention of Clause 11 in this bill, which provides for the civil blacklisting of absconding parents. And Chair, our pride does not merely stem from the fact that we convinced the ANC members in the Portfolio Committee to ultimately give their unwilling support to this clause. It rather stems from the fact that this clause may just help to force a number of parents who are able but not willing to meet their obligation towards their children. It must be said, however, that the unwillingness or inability of the honourable members of the ANC on the committee to appreciate the fact that parents should not be allowed to prioritise either their own expenses or the expenses of children who stay with them under their roof above those who are not living with them clearly illustrates the moral degeneration on this issue in South Africa, and specifically amongst the ANC. Chairperson, this bill will also strengthen the maintenance system in a number of other ways. For example, agreements on maintenance reached outside of the system can now also be made orders of the court. Unfortunately, Chair, this bill will still not assist Mrs. C, the ex-wife of a wealthy businessman, who insists that he's merely an employee of his company, even producing a payslip reflecting a measly salary at the maintenance court, despite the fact that the two family trusts, of which he is a beneficiary, owns the company. Therefore, Chair, our plea to the Deputy Minister is, while a complete revamp of the maintenance system is planned for the near future, this new system must also make provision for lifestyle audits of parents and orders to remove the veil of protection granted to unwilling parents by complicated networks of business interests, aimed at avoiding, amongst other things, the payment of maintenance. Chair, ultimately, every vote in favour of this bill is a message that we stand with hard-working South Africans who believe that parents should take responsibility for the upbringing of their children. As the DA, we are proud of the fact that we could convince the ANC on behalf of those hard-working South Africans to reluctantly support this bill in its entirety, even though we had to drag them here kicking and screaming. I thank you.
Thank you. Honorable Maxson.
Thank you, Chairperson. The EFF strongly believes that the child's right to parent care and to basic nutrition, shelter, and basic health care services is of utmost importance, and both parents are equally responsible to ensure the realization of this right. In South Africa currently, over 48% of children are raised by single parents, and over 90% of child maintenance defaulters are male. As much as the efforts to protect women from the heavy burden of having to care for children alone is appreciated, it is of utmost importance that we acknowledge how issues regarding child maintenance in this country do not exclusively lie to the defaulter but the South African Magistrates Court as well. The amendment bill's primary focus is on legislative framework and legally on the structural framework that should ensure the implementation of policy and legislation. Magistrate courts are characterized by the huge backlogs of maintenance cases, shortage of staff, incompetence of staff, lack of information within the system, and the inability to hold parents accountable for their children's well-being. This means that even with the best legislation and resources at hand, victims of child maintenance default will still enjoy the same challenges experienced before the amendment bill. The EFF also opposes the proposal to blacklist defaulters. Not only does this to disadvantage the person that is unable to pay maintenance, but further to disadvantage the child and other dependents. The amendment bills must also prescribe a standardized formula-based system for determining child support instead of leaving everything to the discretion of maintenance officer. The discretionary system not only makes maintenance officer vulnerable to bribes, but creates situations where complainants are emotionally blackmailed to file for less money than they should file for. In most magistrate courts, boy children get higher maintenance than girl children, further perpetuating the gender stereotypes this bill aims to eradicate. This is another reason why child's maintenance must be standardized, equally taking into account the socio-economic status of the complainant and the defendant. As we are saying we must not punish wrong people. Let us fix the system which are failing our children. We reject this bill. Thank you, Chair.
Thank you. Honorable Msimang.
Thank you, Honorable House Chair. This bill seeks to ensure greater protection for children in families separated by divorce by ensuring their financial needs are timeously met in respect of court-ordered maintenance payments. The bill amends the Maintenance Act of 1998 in order to bring greater improvement and strength to our current system of maintenance through improved and enhanced amendments, such as by increasing penalties relating to certain offences contained in the Principal Act, by ensuring greater regulation around investigation of maintenance complaints, by further regulation around the conversion of criminal proceedings into maintenance enquiries, and in making provision for the granting of urgent relief by allowing our courts to issue interim maintenance orders. Maintenance defaulters will now have to contemplate periods of up to 3 years in jail in the event of a default on payments, and third parties who effect payments via emoluments attachment orders now face up to 2 years imprisonment for non-compliance with such court orders. The bill also makes use of current technical advances by empowering our courts to order that maintenance payment evaders' locations be tracked using their cellular telephone service providers, which will greatly assist in ensuring that our police services and sheriffs are able to track, trace, and ensure service and compliance of maintenance court orders. The clause allowing the blacklisting by credit bureau of maintenance defaulters is necessary, and we are pleased to see that it has now been included and carries broad support in this amendment bill. In conclusion, this bill represents a great step forward in narrowing down the loopholes of the 1998 Maintenance Act by greater regulation, stiffer penalties for contravention, greater use of current technology in order to enforce its provisions, and all in the interest of the greater welfare of our children. The IFP supports this bill.
Thank you, Honorable Msimang. Honorable Mngwabe.
Thank you, Honorable Chairperson, honorable members. The NFP supports and welcomes the Maintenance Amendment Bill. South Africa has an unacceptably high rate of maintenance default, which leaves children and former partners destitute and clogs up the court system. We believe that the amendment to the Maintenance Act are progressive and long overdue. We believe that in particular, the NFP welcomes the measures to compel maintenance defaulters to meet their obligations by putting their credit worthiness at risk, and to empower the maintenance court to order institutions such as cell phone service providers and telecom to provide traceable contact details of maintenance defaulters. The NFP also welcomes the proposal that where a divorce is done by agreement, which adequately set out the respective maintenance obligations, the requirement for the parties to appear before the maintenance court is dispensed with. We believe that this amendment will reduce the workload of the maintenance courts and expedite divorce proceedings. We also welcome the provision which allows maintenance courts to make interim maintenance orders pending the finalization of maintenance inquiries. This amendment is of a great importance to address the frustrating situation where persons who clearly have maintenance obligations try to delay as far as possible the granting of a maintenance order against them. Such delays, Chairperson, is to the detriment of women and children and should not be excusable. The net effect of the amendments, as set out in the bill, is to make the maintenance system more effective and, more importantly, to streamline the processes relating to the investigations by maintenance officers and investigators. For far too long, maintenance defaulters have avoided their obligations almost with impunity. Now, the long arm of the law will reach further and justice will be dispensed far more effectively than before. The National Freedom Party submits that should the Maintenance Amendment Bill be adopted, women and children will benefit, and in particular, the constitutional imperative of the best interest of the child will be served. We support this bill. Thank you.
Thank you. As achtbare lid Alberts in die huis. Say he's nie hier nie. We go on to Honorable Madisha.
Chairperson, the maintenance of children in our country is very important. The Maintenance Amendment Bill will amend Act number 99 of 1998. It gives maintenance courts sharper and bigger teeth. Once the bill is signed into law, a maintenance officer can institute an inquiry to substitute or discharge a maintenance obligation that was never made an order of court. Henceforth, it will also not matter whether a maintenance beneficiary lives or works in the area or jurisdiction of the court. Either of those conditions will be acceptable for the court. The bill thus expands the jurisdiction of the court. This bill will also empower a court to ask phone companies to furnish contact information of a person affected by an order of a misconduct court. The court will decide who pays the cost of this service depending on conduct and behavior. Where a person who is paying maintenance seeks a reduction or discharge of the maintenance order, the maintenance officer will have the power to subpoena the beneficiary of a maintenance order as well to make a determination. The bill, importantly, places a duty on a maintenance court to conclude maintenance inquiry as speedily. Failing that, for reasons beyond its control, it can make an interim order for maintenance. This is definitely an improvement. The bill takes note of judgments in the High Court. Before a court order or court orders a person's earnings to be attached, the employer will have an opportunity to comment on the feasibility of such an order before it is made. This makes sense. Defaulters or beneficiaries who cannot attend court but who consent in writing to an agreement before a maintenance officer at an inquiry will allow a maintenance court to make an order in the absence of either a party or both parties. Where a person ignores a subpoena,
Honourable Member, your time has expired.
we support. Let's go.
Thank you very much. Achtbare lid Albert is nou terug. Gaan voort met die debat, achtbare lid.
Baie dankie, voorsitter. This bill that serves to bring justice to maintenance matters pending the finalization of the South African Law Commission's review is a welcome change to the current maintenance system. Daar is geen twyfel dat die onderhoudsstelsel soos dit tans daar uitsien gebrekkig is nie. Geskeide persone, veral vrouens wat dikwels die kinders uit die vorige huwelik moet versorg, staar geweldige ontbedings in die gesig indien onderhoud nie betaal word nie. Hierdie mense is magteloos in die aangesig van 'n vorige gade wat bloot net nie sy of haar onderhoudsverpligting nakom nie. Hierdie mense het dan ook gewoonlik nie die vermoë om 'n prokureur te nader vir regshulp nie. The result of non-payment of maintenance is in effect to visit a double tragedy on the children. Not only are they witness to the breakup of the family structure with all of its ill effects, They must now face the prospect of a lack of income and further animosity and strife between their parents. As the state sanctions the institution of marriage and is tasked with protecting the interests of children by virtue of its human rights obligation in terms of the Constitution, it is also incumbent upon the state to create an effective and equitable legal system whereby the broken family's interest must be protected. Alhoewel die meeste van die wetswysigings tegnies van aard is om effektiwiteit te verhoog, is daar wel een wysiging wat probleme kan skep. Dit handel oor die moontlikheid wat geskep word om 'n wanbetaler te swartlys. Daar is nie probleme met die beginsel om iemand op die wyse te dwing om sy verantwoordelikheid na te kom nie, maar dit kan wel onbedoelde gevolge hê, soos dat die wanbetaler probeer aansoek doen om 'n klererekening vir sy kinders en geweier word, of aansoek doen om 'n lening vir skuldkonsolidasie om sodoende sy finansiële verpligtinge teenoor die gesin na te kom, maar geweier word. It would therefore be prudent to allow for a system whereby the defaulter can apply to have his name removed from the blacklist if any accounts are opened or debt created that would be to the advantage of the ex-spouse and children. It is our hope that the South African Law Commission will relook this matter. Dit is duidelik dat die wetsontwerp poog om 'n billike balans te handhaaf tussen die belange van die aansoeker om onderhoud en die ander partye betrokke, soos die werkgewer en die onderhoudsbetaler asook die onderhoudsbetaler self. Dit is insiggewend dat 'n verstekvonnis net gegee kan word indien daar duidelik aangetoon kan word dat die ander party werklik bewus was van die verrigtinge en willens en wetens dit nie bygewoon het nie. It is not every day that one can debate a relatively non-contentious bill in Parliament. We wish to thank all of the MPs who worked on this bill and are looking forward to a renewed and even better version after the Law Commission's final report. I thank you, Chair.
Thank you. Akbar Swart.
Thank you, Chairperson. Chairperson, the ACDP has always believed that healthy families form the bedrock of healthy societies. Regrettably, however, we have many dysfunctional families, with absent fathers being a particular problem. Many millions of South African children grow up in single-parent households, and in thousands of cases, absent fathers do not pay much-needed maintenance for their children. Now, if I was to ask the honourable members what was the record in 2013, the record was 223,000 rand, 848 rand that was owed by a maintenance defaulter. Thankfully, he was brought to book by the department, and he had 2 children, 11 and 14, and so we see that this is a continual problem. And the Maintenance Act, whilst it has been comprehensively reviewed by the South African Law Commission, has been amended with these interim measures which are to improve access and obtaining of court orders. And it also implements certain High Court decisions that affect maintenance matters. One of the only contentious issue related to whether maintenance defaulters should have their names blacklisted. And surely this makes sense, as why should a maintenance defaulter be able to purchase an expensive car, home, electronic items on credit for himself when he has reneged on his maintenance payments? Whilst on the other hand, it was argued that this may result in fathers not being able to access credit to pay maintenance, the possibility of blacklisting surely may urge more defaulters to pay, and that is why we from the ACDP support the insertion of that particular clause. The ACDP also supports the department's initiative to name and shame errant fathers who do not pay maintenance. Fathers often deny paternity, and when the tests come out positive, they are still reluctant to care for their children. This, in our view, is shameful. It is also important that maintenance defaulters are effectively and speedily traced to ensure that those court orders are complied with. There can be no doubt that this amendment bill is a step in the right direction whilst we are having this comprehensive review of the maintenance issue. It relates directly to the poor and vulnerable in our society, and the ACDP will support this bill. I thank you.
Thank you, Honourable Swart. Mhlomphehi Mthapo.
Our children are our greatest treasure. The African Charter on the Rights and Welfare of the Child recognizes that the child occupies a unique and privileged position in African society and calls on parents to secure, within their abilities and financial capacities, the conditions necessary for the child's development. Chairperson, key to that development When relationships between parents break down, so is access to maintenance. The primary responsibility or duty for the support of a child rests with the parents. This responsibility continues whether or not the relationship between the parties survives. However, Chairperson, maintenance is about more than parental obligations. It is also a fundamental children's right issue. Ultimately, the protection of children's rights is a collective responsibility. Section 22, subsection 2 of the Constitution, Honorable Tlengwe Maxson, specifies that the best interests of the child are of paramount importance in every matter concerning the child. This constitutional commitment is echoed in the Children's Act 38 of 2005. The Act provides that parents must care for, maintain contact with, and contribute to the maintenance of their children. This includes the provision of the basic necessities of life, such as shelter, food and clothing, medical care, and education. Access to maintenance is not just about a duty of support, it is also about poverty alleviation. Despite overall poverty being much lower than in 1993, poverty still has a racial and gender aspect to it that must be overcome. 39% of all children, more than 7 million children, live with their mothers but not with their fathers. Halala Mbogoto. In South African society, it is still predominantly women who care for children. Statistics indicate that households headed by women are between 38% and more than 100% poorer than households headed by men. 90% of maintenance defaulters are fathers. This means for many women, a well-functioning maintenance system is an essential tool in alleviating economic hardship. Chairperson, in 1994, South Africa was confronted with an inefficient, ineffective, fragmented, and racially divided maintenance system that required urgent attention. Shortly after the ANC was voted into power, the Maintenance Act 99 of 1998 was introduced to address some of these systemic challenges and give effect to Section 28 of the Constitution. This resulted in significant improvements to the existing system. The overall turnaround time for maintenance cases has decreased, and there has been an improvement in service, especially through the increased use of electronic payments. Honorable Hon. However, 17 years later, this act is due for a significant overhaul. This process will be led by the South African Law Reform Commission. My colleagues have already alluded to 3 important key amendments contained in the bill. Firstly, it provides for the granting of interim maintenance orders. The amendment places a duty on a maintenance court to conclude maintenance inquiries as speedily as possible. However, should the court have to postpone maintenance inquiry, it can now make an interim order for maintenance pending the finalization of the matter. Chairperson, secondly, tracing evasive maintenance defaulters. If a court is satisfied that all reasonable efforts to locate a defaulter have failed, the court may now order one or more of the electronic communication service providers to furnish the court with a defaulter contact information. You know, in terms of Financial Intelligence Center Act, you provide your details so that you can be properly traced. So, I want to chabelan. Thirdly, regulating the reporting of a maintenance defaulter to a credit bureau. When a court grants an order because a defaulter has failed to pay maintenance, that person's personal details must now be submitted to a credit bureau for blacklisting. Maybe that's why Honorable Member from EFF is totally opposed to this bill. However, Honorable Chairperson, it is not true that the ANC was not in support of this third amendment. We were still busy engaging, Honorable Hon. Unfortunately, you mobilized DA members to come and I don't know whether it's doi or what kind of a dance in front here. Unfortunately for you, ANC as a very progressive organization which understands the policies of this country then came back and advised the department to find other options. And as the department couldn't find anything, we then have to agree to this. Not because we were pushed. We were never pushed, and we shall never be pushed. Why subject ourselves to your policies? Never. Honorable Chairperson, as the ANC, we therefore fully support this very progressive amendment bill. Thank you.
Thank you, Honorable Member. Ilungu elihloniphekile uhlonipheki Nchayisa.
Thank you, Honorable House Chair. Honorable House Chair, the work that has been done by the Portfolio Committee on Justice and Constitutional Services needs to be applauded. It has been easy for the culprits or the maintenance defaulters just to run away from the rule of law because of certain loopholes in the Act. However, it is not always the case that the plaintiff is correct. We accept the fact that a thorough investigation has to be made now. There are always two sides of the coin. What is important is that men should learn to maintain their kids so that you don't have these street kids or gangsters. It is good that maintenance inquiries are to be speedily concluded in future so that complainants do not give up. Clause 1, Section 6 of the Act has been amended. That talks about investigation. It is good also that now a verbal or a written agreement has to be recognized. According to Clause 2, Section 6, thorough efforts are to be made to locate those affected by the maintenance order and other means to get conduct of these defaulters are also to be made. Another relevant amendment according to the Clause 3, Section 6 is that both respondent and beneficiary may be summoned to appear before the maintenance court to give evidence of the financial positions, not only the respondent. However, I think now the wives also at home now should give support to their men so that they support even the kids now that are outside the marriage. Because it is always the problem now, when a man is willing to support, then the wife now would be reluctant to allow the husband to do so, to support the one outside. So they also should be responsible. AIC supports this bill because it seems now it is sort of a service delivery to our people. Then beneficiaries will gain a lot, will no longer have these problems that are always affecting our people, rather our children. Honorable Chairperson, I'm still looking for two young men now who made havoc in my house. Then that is why I supported this bill, because these young men really now have got to be looked after thoroughly so that they don't do this. They should learn to support, and a man has got to be held responsible for his evil deed. You know, if you don't support or you don't maintain your child, then it should be something that comes to your mind and makes you want to not be working. So I do support the bill, and as I say now, we do support this bill because it's a good progress. Thank you very much.
Thank you, Honourable Member. The next speaker is the Honourable Pilane Majake.
Honorable House Chairperson, the bill is drawn in the best interest of the child and any other person whose livelihood is dependent on the maintenance order to continue to support and adhere to developmental state principles guided by the ANC. The purpose of the bill is to amend the Maintenance Act 1998 so as to further regulate the lodging of complaints relating to maintenance and the jurisdiction of maintenance courts, to regulate maintenance inquiries in order to make provisions for granting of interim maintenance orders, to regulate the making of the maintenance orders and by consent, to regulate the circumstances in which maintenance orders may be granted by default, to further regulate the granting of cost orders, to regulate transfer of maintenance orders, to regulate the reporting of maintenance defaulters to any business which has as its objects the granting of credit or is involved in credit ratings of persons, to further regulate the attachment of emoluments, to increase the penalties for certain offences, to create certain new offences, to further regulate the conversion of criminal proceedings into maintenance inquiries. The main focus of the bill is to provide an interim order where there is no final order to prevent undue hardships on the part of children or persons to be maintained pending finalization of the matter. Because previously what used to happen is if there is a process that's taking place that may actually end up with a maintenance order, in the meantime you'd actually find that children and people depending on the outcome of the process would suffer in the meantime. So with this arrangement, it means that you will not have a process where there is a divorce that is a proceeding that's taking place. On the other hand, the children are suffering. Electronic service providers may be used to provide information on defaulters who should in turn pay costs for such services. The state is to pay costs recoverable from the defaulters if the complainant is unable, by means test, to pay the costs. After the evidence, either in writing or orally from the employer of the person in question, who is a defaulter, an order may be made for the attachment of emoluments at present or in future owing to accruing to the person. This is very important in the sense that previously what used to happen, you'd actually find that there will be mostly fathers who would actually default when in actual fact they can actually manage to afford. So this clause will then therefore take care of such situations of people who can afford but end up having too many reasons that make it not possible for them to continue to support the children. And we should always bear in mind the fact that all the arrangements about maintenance can actually work both sides. Either it's the mother that supports or the father. Any person who fails to make any particular payment in accordance with the maintenance order shall be guilty of an offence and liable on conviction to a fine or to imprisonment without the option of a fine, which really becomes a deterrent. The intention is not to punish, but to say that we have provisions that would actually take care of a situation where maintenance is not actually adhered to. The bill also looks at transfer of high court orders to magistrate courts, just to actually help facilitate the whole process of maintenance. It is quite encouraging to see the number of political parties that have actually supported the bill. And to the EFF, we actually wonder as to why you have to actually continue to not support even provisions and bills and arrangements that are actually also going to be benefiting the people you so dearly care for as a political party. Honorable Nixon, the legislative framework is there, and then you worry about the structural arrangements. Today we are actually looking at the bill, which is just the legislative framework. And of course, the departments are there to actually worry about the logistical arrangements around this. And if possible, where there is need, we will actually have enabling regulations that would take care of anything that might be something that you think may not have been covered properly. And the ANC continues to support Clause 11, which is about the submission of names of defaulters to the Credit Bureau. And we have never, ever relegated this responsibility. When the DA really made a lot of noise about it, it was because it was a committee process. Whilst talking about it, debating and discussing, and we pause, we say we'll meet tomorrow. By the next day, you find that the DA has already managed to identify something that they can actually manage to utilize for political points scoring. It shouldn't happen like that. The ANC supports the bill.
I now call upon the Honourable Minister of Justice and Correctional Services responsible for justice and constitutional development.
Thanks, House Chairperson, and thanks to the members and the parties in the House that supported the bill. This bill will make a big difference to the thousands of maintenance beneficiaries in South Africa. It's a pity, though, with such a bill that's of such importance to so many people, that there was some politicking. From the DA's side, I know that you use maintenance as a campaign issue, but your comment, Honourable Horn, about the moral degeneration of the ANC, I mean, this bill came from an ANC-led ministry, from an ANC-led cabinet. So don't separate the ANC between the executive and the legislature. And the Portfolio Committee were wanting to consider all the options. Now, as far then as the EFF, which was the other issue, it's a pity that the Honourable Maxson couldn't attend any of the Portfolio Committee meetings where she could have raised the issues with officials. But it's not, I mean, maintenance is, you want standardization, but the amount of maintenance that's paid depends on the circumstances of the person, how much they're earning, how many dependents that they have. The other parent, how much they are earning, if anything. If a person is not working, if they don't have a salary, then they can't pay maintenance. And so your concern that you reject the blacklisting because it will affect people unable to pay maintenance is actually not true. Because if a person has had a maintenance order against them and they then lose their job, they must go back to court and inform the court of that, of the change in the circumstances. So it won't affect anybody who can't pay maintenance. It will affect those people who would rather pay for their DSTV subscription than support their child. To the Honourable Horn as well, I mean, there are maintenance inquiries. We can look at whether we can tighten up the provisions. But if there's evidence that the father, let's say, is getting money from a trust, then evidence should be led of that. And there are maintenance investigators to assist in the matter. In KwaZulu-Natal, for example, the regional offices bought cameras for the investigators to look for parents that are employed in the informal sector to go and take photographs of their businesses or their operations to go and give that to the court. As far as the complaints from people in the system, that's something we are continuously trying to work with. It was, as the Honourable Horn had said, there has been a dramatic increase in the number of applications. There has been an increase in the staff, but we're continuously trying to improve the service. We do have complaints numbers in each of the provinces where people can complain if the service they feel wasn't adequate. But generally, again, to support all the parties, with one exception, and hopefully they'll read the bill, for their support for this bill. And I thank you, House Chairperson.
Thank you, Honourable Deputy Minister. Honourable members, that concludes the debate. Are there any objections to the bill being read a second time? No objections. Agreed to. The Secretary will read the bill a second time.
Maintenance Amendment Bill.
The bill will be sent to the National Council of Provinces for concurrence. The Secretary will read the second order.
Second reading debate agreement, South Africa Bill.
I now invite the Honourable Martins, the Chairperson of the Committee.
Honorable House Chairperson, honorable members of Parliament, the Agrima South Africa Bill seeks to establish Agrima South Africa as a juristic person and to make the Public Finance Management Act of 1999 as amended applicable to it. The objects of the Agrima South Africa as contained in Clause 4 of the bill are to A, provide assurance to specifiers and users of the fitness for purpose of non-standardized construction-related products or systems. B, to support and promote the process of integrated socio-economic development in the Republic as it relates to the construction industry. C, to support and promote the introduction and use of certified, non-standardized construction-related products or systems in the local or international market. D, to support policymakers to minimize the risk associated with the use of a non-standardized construction-related product or system. And E, to be an impartial and internationally acknowledged South African Center for the Assessment and Confirmation of Fitness for Purpose of Non-Standardized Construction-Related Products and Systems. In conclusion, the main function of the Agrima South Africa Bill is assessment and certification of non-standardized construction-related products or systems. I request the House to support and adopt the bill. I thank you.
Honourable members, there has been a request for declarations. I'll now allow political parties up to 3 minutes to make those declarations.
Thank you, Chairperson. Chairperson, Agrimo South Africa is an institution that reports to the Department of Public Works. It has all along operating under the CSRR even from their offices. The purpose of this bill is clearly to establish a juristic person, and there are other reasons that are. But its most mandate is to certify every new product that is not approved by the SABC, to ensure that it is fit for purpose, as the chairperson have said. And I think it is also important that we can actually understand who is actually the innovator rather than the testing for fit for purpose. There are some products on the market that Agrimo South Africa has actually certified so far. The certificate is valid for 3 years and it must be renewed after every 3 years. Annually, Agrimo South Africa was able to present its strategic plan and its annual achievements, but not the financial statement, which is crucial to the committee. With the approval of the bill, we can now hold Agrimo South Africa accountable for its financial report, as well as to ensure that actually they comply with the PFMA. That is one of the reasons why we support the bill, as it is also not controversial. The bill was thoroughly interrogated with the department as well as the state law advisors. The DA will now monitor its implementation after it has been signed as an act by the President to ensure that they really do their job. I thank you.
The EFF.
Thank you, Chair. In our funding manifesto as EFF, our cardinal pillar number 3, it talks to the state building its own capacity for the construction and maintenance of infrastructure such as roads, railways and dams, and other specific basic services such as schools, houses and hospitals. Currently, this bill opens up opportunities for certification of non-standardized construction products across the board and does not specify the need for locally produced products. This means that the country can in the near future expect a flood of non-standardized construction products from other countries, which would then be satisfied by Agrimo South Africa. This will be the death of innovation, research, and development in our own country, as was the case with the textile industry, which died when the doors of our borders opened for cheap exports from China. The cement industry is already in trouble. Countries such as Vietnam and Pakistan already have 7% market share of the country's cement. They have been accused of dumping substandard cement in our own shores. The EFF therefore submits that the agreement South Africa has the potential to be transformed into a developmental agency, focused primarily on building up the capacity of our own innovators in the construction industry. With a strong government intervention and support and equivocal protection of our construction manufacturing sector, we can be in a position to produce many products needed for our construction needs. Agreement South Africa, therefore, should not be limited to just being a certification body for products, most of which will be originating from outside the country. It must be utilized as a vehicle for inward-looking development and industrialization. This can then be supported in the long term by creating a state-owned construction company to ensure that all locally produced construction materials are procured and utilized by the state. As it currently stands, the agreement bill falls far too short on these requirements. So the EFF rejects and will not support this bill.
The IFP.
Honourable House Chairperson, the IFP support and welcome the establishment of Agreement South Africa as a juristic entity, as well as the applicability of Public Finance and Management Act to this entity. The able body support and promotion of process of integrated social economic development in South Africa as it related to construction industry is crucial and must be done through the introduction, application and utilization of satisfactory innovations and technology development in a manner which will add value to the process. Agreement South Africa position is the internationally acknowledged objective South African Center for the Assessment and Certification of Innovative Non-Standardized Construction Products, System, Materials, Component and Processes, which are not fully covered by South African Bureau of Standards or Code of Practice. It must be supported. And only thing that we ask the minister, the deputy minister, to look at is the name of Agrema, because it doesn't actually reflect the South African names, because Agrema, sometimes you don't know what kind of a language. Thank you very much.
Thank you, Honourable Member. Are there any further declarations? There's no further declarations. Are there any objections to the bill being read a second time? There's no objections. Agreed to. The bill will be sent to the National Council of Provinces for concurrence.
Chair.
Sorry.
Honourable Chair, we are objecting.
There is an objection.
Please note our objection as EFF.
We'll note your objection. The Secretary will read the bill a second time.
Agrema South Africa Bill.
The bill will be sent to the National Council of Provinces for concurrence. The Secretary will read the third order.
Consideration of report of Portfolio Committee on Cooperative Governance and Traditional Affairs on Disaster Management Bill.
I now recognize the Honourable Chief Whip of the Majority Party.
Honourable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? No objections. Agreed to. The Secretary will read the fourth order.
Second reading debate, Disaster Management Bill.
I now invite the Honourable Mdakane, the chairperson of the committee, that will address the House on the bill. The Honourable Mdakane.
The Honourable Presiding Officer, Honourable Ministers, Deputy Ministers, Honourable Members. The Disaster Management Act 2002 was promulgated in 2003. A number of challenges were experienced in the various spheres of government in implementing all aspects of the legislation effectively. During 2010, practitioners and stakeholders in the field of disaster management, as well as research undertaken by SALCA, the African Center for Disaster Studies, amongst others, highlighted some areas which were identified either as gaps in the Principal Act or as issues which are impending on hampering the effective implementation of the Act. Giving the view expressed by practitioners, academics, and other members who are participating, members of the communities, and after consultation, we have discussed with them. We then agreed that the bill need to be strengthened, need representation of traditional leaders. We need to deal with the question of management structures, that we need to incorporate obligations set out in a framework of action adopted by United Nations in 2005, to have the national platform for disaster risk reduction. We have also discussed the issue of the roles and responsibilities of organs of state in a disaster management, emphasizing the need for organs of state to assist the disaster management structures in event of disaster or a potential disaster. We have also clarified on the specific information and reporting requirement to municipal and provincial intergovernmental forums. The content of the disaster management plans by organs of state and making the applicable information available to relevant disaster management centers. We reaffirm the role of municipalities to establish capacity for the development and coordination of a multi-sector disaster management plan and implementation of disaster management functions for the municipalities. The key issues that were raised by various stakeholders during the consultation process and in the meeting that we had with them, they raised the issue. The committee met with them, have a discussion with professors, with practitioners, with members of communities who were able to come to Cape Town to have a discussion on the main issue of a disaster management amendment bill. This is not a principal bill, it's an amendment. On some of the issues was the issue of terminology. On some other areas was just the technical languages trying to be in line with national and international convention. And we have met with SALCA, we have a discussion with them. They raised some of the issues that they thought in their own view that this is an addition into the function that are given to them. We sought legal opinion, we engaged with them. They agreed that is not a new function that is assigned to them. They always have the role to play in disaster management. And SALCA is happy with this. And Honorable Presiding Officer, the committee and all members of the committee accepted the amendment as we presented. Today, we think members of the House will accept the amendment bill, and the Principal Act is still in existence. We are just amending the Principal Act. Then we think the members of this House will accept the amendment and work to ensure that all our structures set up disaster management centers in all spheres of government, but also major entities or government structure. Thank you, Honorable Chairperson.
Thank you, Honourable Member. There's been a request for declarations. The DA.
Thank you, House Chair. While the DA will support this bill, we do have a number of concerns. But perhaps before we get there, we need to have a look at what this bill does for the country. It establishes the National Disaster Advisory Management Advisory Forum to serve as South Africa's platform for disaster risk reduction. In terms of its international obligations, in terms of the Hyogo framework of action adopted by the United Nations in 2005. So here we are aligning our legislation with international agreements and obligations. It also sets aside the National Disaster Management Centre as a component of government in terms of the Public Service Act. This is a good thing because it allows the assignment of the function of disaster management to be moved from one ministry to another as per the decisions of the President. And the head of the National Disaster Management Centre will then will report to the Minister. brings in various amendments that allow for the Disaster Management Centre to call on other organs of state like the National Defence Force and the South African Police Services to assist it. And then it also requires that local government undertakes certain disaster risk reduction and disaster management planning activities. Now, it's this area where we have some concerns, because this is an item that SALGA raised, and contrary to what the chairperson of the committee said, I don't believe SALGA actually agreed at the end of the day with the assessment that this was not a new assignment. So the problem then is, how do you fund this assignment? And this then becomes the real issue. It is our belief that we are imposing a mandate on government, on local government, that will then require them to submit plans, disaster risk reduction plans, disaster management plans, where they don't have capacity to perform that function in-house. They are then going to go to consultants, etc., incur costs, and this is then an unfunded mandate. It is this concern that we are raising. We're not saying no to the bill. We are saying it is an area that we are going to monitor, we are going to watch, and see how it develops over time. Just one other aspect that we must commend the department on, and that is the bringing of the Disaster Management Act through this amendment in line with the Sendai framework for disaster risk reduction. And that was signed in March 2015, so the department must be commended in that regard. The DA will support this bill.
The EFF.
Thank you, Honorable Chairperson. The poor in this country, particularly black people, have, as a result, not only of natural disasters, but also the infrastructural impediments of town planning of apartheid. They live under a permanent state of disaster. The Disaster Management Act and National Disaster Management Framework of 2005 as overarching policy and legislative frameworks are quite explicit on the various institutional arrangements needed for effective disaster risk management, but these structures are not in place, and when they are mostly not functioning. This amendment bill is not focusing on giving any significant substance to the need for strengthening institutional structures. It still does not clarify the role of local municipalities for disaster risk management, and still confines the role of disaster risk management to districts and metropolitan municipalities. While the content of the amendment bill makes the bold and long overdue commitment to expanding the focus of the Act to disaster risk management, the title of the bill still reflects the long-standing resistance to include proactive risk management mechanisms instead of reactive management of disaster after they happen. The name should ideally change to Disaster Risk Management Act to reflect international best practice and our commitment to decisively risk with the socio-economic vulnerabilities that expose our people to preventable disasters. This amendment bill does not deal at all with the most fundamental aspects of disaster risk management, and that is the socio-economic realities that subject poor people to preventable disasters. A prime example are the conditions of informal settlements in Cape Town. Every year in winter, our people, the poor in particular, experience the same challenges of having their informal settlement houses flooded by the winter rains in Cape Town. This amendment bill does not provide any legislative solution to the problem of this nature and has no mechanism of holding into account metropolitan councils like the DA-led city of Cape Town, which has no desire to trouble itself with the well-being of the poor and the blacks in the informal settlements. While this amendment bill is well-meaning, it does not go far enough to effect the kinds of changes we would want to see. So the EFF is not going to support it until you are serious to make proper changes. Thank you very much.
The IFP.
Thank you very much, Honorable House Chairperson. As already been indicated that certain amendments had to be made to the Principal Act, and amongst other things, of course, is the discussion around disaster management and disaster reduction. And the committee was given the assurance by the department that when we refer to disaster management, disaster reduction is included in that. And we have incorporated in our discussions as the committee the areas that have been raised by the experts in the field of disaster management. And so we are pretty comfortable that moving forward, in order for the bill for it to actually make any meaningful sense to the people, these things must be taken care of. Of course, we don't expect the Act to be specific, but it should provide a framework upon which municipalities can submit their frameworks and to ensure that the frameworks are responsive to the realities on the ground as opposed to imposing a national direction. We do want to emphasize that the SALGA had raised serious concerns about the issues of this being a new mandate and the issue of funding on top of that. And the legal conclusion that we arrived at, or advice we were given, was that this was not a new mandate. But what is important is that National Treasury has given the assurance, and it is upon this basis that the IFP will support this bill, that funding will be made available, because we believe that funds must follow function. And so it would have been unfair to impose on municipalities the type of things that are being given to it now in terms of what it should do in the absence of providing funding. So the assurance and commitment given to us by National Treasury is by and large the basis upon which we are able to move forward to ensure that municipalities are not set up for failure by giving mandates which are unfunded and outside their jurisdiction, because it would be a futile exercise anyway to give municipalities a mandate which they are unable to execute, and a mandate which is not going to be beneficial to them. So we do expect that National Treasury will live up to its commitments and ensure that funding is made available. We also want to emphasize that municipalities must not be viewed as junior partners of government, because there does seem to be a tendency that everybody looks to municipalities as the small boys in the scheme of things when it comes to the development of the country. And it is that resistance and that unhealthy working relationship between local government and other spheres of government which is causing the resistance. And so that must be an issue that must be addressed, because we cannot afford every time that the stumbling block is relational in terms of how we're moving forward. So in supporting this bill, we want to really emphasize as the IFP that the important thing is that funding must be made available to ensure that disaster management is carried out in a manner which serves the collective interests of our people. I thank you.
Thank you, Honourable Member. The NFP.
Honourable Chairperson, the assignment of disaster management functions to all municipalities is supported. We do have a share SALGA's reservations with regard to the process followed, and we also have reservations regarding the funding provision for the newly imposed obligations for municipalities. We need to ensure that we avoid creation of an unfunded mandate for municipalities, since the equitable share allocated to municipalities does not include any component for disaster management. The NFP is of the belief that it is important for transparency purposes that disaster management should be well standardized, so that all role players are on par as to what constitutes a disaster, what criteria to be used to determine its nature and extent, how funding is to be regulated, and who the intended beneficiaries are. Most important, however, is that a standardized and integrated disaster management system should have the minimum bureaucratic red tape for disaster relief. People who bear the brunt of a disaster are more often in most need immediately after such disaster occurred. And that is the point where relief management will have to be flexible to provide much needed support as soon as possible. Red tape could seriously dilute the effectiveness of disaster management. Despite our reservations, however, the NFP supports the disaster management bill. I thank you, sir.
Thank you, Honourable Member. The Freedom Front Plus.
Agbare voorsitter, die Vryheidsfront Plus sal hierdie wetsontwerp ondersteun, en in hierdie wetsontwerp word daar baie aandag gegee aan die nasionale rampbestuursentrum. Maar ek wil vandag vir ons mense sê, agbare voorsitter, as 'n ramp plaasvind, is die belangrikste komponent van eerste optrede die plaaslike vlak van regering. Ek het dit fisies beleef in Stilfontein in 2005 met 'n aardbewing, waar die plaaslike rampbestuur nie in staat was of bevoeg was om die situasie te kon hanteer nie. en moes hulle die plaaslike Klerksdorp Kommando ingeroep het om die ramp te bestuur. Die feit van die saak is, daar bestaan nie meer so iets soos kommandos nie. En ek wil vandag vir u sê, dat as ons effektiewe rampbestuur in Suid-Afrika wil verseker, dan moet daar toegesien word, en ek wil 'n beroep op die agbare minister doen, om toe te sien dat elke plaaslike regering die nodige toerusting het, en die nodige mannekrag om die behoorlike uitvoering van hulle pligte te kan uitvoer in terme van rampbestuur. Want as ons dit nie het nie, dan kan ek u verseker, gaan die gevolge van die ramp net groter wees. Want ons weet, effektiewe rampbestuur is juis om die nadele, of kan ons amper sê die slegte gevolge van 'n ramp so ver moontlik te beperk. Daarom ons sal dit ondersteun, maar ek doen 'n ernstige beroep op die minister om te verseker dat die eerste vlak van optrede in rampbestuur, dat hulle behoorlik toegerus is, behoorlik opgelei is om dit te kan doen. Ek dank u.
Thank you, Honourable Member. Go.
Thanks, Chair. In terms of the Hyogo framework of action adopted by the UN in 2005, our country has to align with it to achieve national disaster risk reduction. Risk reduction is more important than risk mitigation. The bill provides for the establishment of the National Disaster Management Center as a government component in terms of the Public Service Act. Whenever that happens, NDMC will be competent to call on the Defense Force, on the police, and any other organ of state to assist the disaster management structures when required. NDMC is also empowered in the bill to interact with a relevant provincial disaster management center to avert a disaster or to manage it. All relevant organs of state will have to participate in an extended reporting system to the NDMC on the progress being made in implementing measures in this bill that relate to them. They need to prepare on how to respond swiftly and correctly. What happened, for example, in Nepal should serve as a warning to us as South Africans. After a disaster, the government must have a plan and the capacity to implement post-disaster recovery and rehabilitation measures. All parties must report on the kind of the specific problems experienced by any organ of state in dealing with a disaster. This is important, Chairperson, to record. Areas overlooked are financial control in the post-disaster and rebuilding a period and the inclusion of persons and NGOs with disaster management expertise. The Minister must, at an early stage, provide this House with details of how organs of state are preparing for climate change impacts. COPE will support this, but the early mapping of risks, potential disaster areas, and endangered ecosystems have got to be looked at. We also want to look at a thorough mapping of communities and households that are vulnerable to physical and human-induced threats. What the Minister has got to do
Honourable Member, your time is now expired.
Okay, thank you.
Thank you. The ANC.
Thank you very much, Honourable House Chair. The ANC would like to thank and appreciate the support that all parties are giving for this amendment bill. We just want to clarify two aspects. And before I clarify these two aspects, I wish to say that the ANC has received, the committee has received two opinions, one from the state law advisors and the second one from the legal division of Parliament. And all the opinions are agreeing that this amendment bill does not introduce new assignment to local government. It re-emphasizes the functions that local governments have been having in terms of disaster management. So there is no issue about the new assignment. With regard to SALGA discussion, SALGA has been sufficiently accommodated. The views that SALGA has raised have been sufficiently accommodated in the amendment bill, and we think that as part of the implementation of the bill, we will continue to engage with SALGA to identify those difficulties that might exist during the process of implementation. The issue about the risk, disaster risk reduction versus disaster management. For us, Honorable House Chair, it's a matter of semantics because the bill sufficiently identify and list the activities that constitute risk reduction. And therefore, as the ANC would like to submit that the bill assist in terms of making sure that the necessary structures are created for us to be able to respond to disaster management. Thank you very much.
Thank you, Honourable Member. Honourable Members, are there any objections to the bill being read a second time? There's no objections. Agreed to. The Secretary will read the bill.
So, Chairperson, would like you to record the objection of the EFF.
Objection will be recorded.
Thank you very much. Of Mr. Cash.
Are there any further objections? No further objections. The Secretary will read the bill a second time.
Disaster Management Amendment Bill.
The bill will be sent to the National Council of Provinces for concurrence. The Secretary will read the fifth order.
Consideration of recommendation of candidates to fill vacancies on Council of Independent Communications Authority of South Africa, ICASA.
I now invite the Honourable Member from the committee to introduce the report.
Thank you, Chairperson. This is the report of the Portfolio Committee on Communications on the filling of the 5 council vacancies on Independent Communications Authority of South Africa, that's ICASA. The Portfolio Committee on Communications considered 2 letters from the Minister of Communications informing the Assembly that the terms of office of Independent Communications Authority of South Africa, Councillors Mr. William Curry and Mr. Joseph Leboa, will expire on 3 September 2014, and the terms of office of Mr. William Stark and Ms. Ntombizoto Ndlovu on 31st October 2014, and informing the Assembly that she accepted the resignation of Dr. Mashia Sotkikwa, a councillor of the Independent Communications Authority of South Africa, with effect from 31st January 2015. The committee advertised the call for nominations of persons to serve in the ICASA Council. 85 nominations were received and considered by the committee. On 17 March 2015, the committee adopted the following names as a subcommittee to shortlist and recommend appointments. Honorable J.C. Mulwe Muropa, Chairperson and NC Member, Honorable G. Davis, DA, Honorable M. Dlozi, EFF, Honorable Sotesi, ANC, Honorable Tedi, ANC, Honorable Kekana, ANC, Honorable Madisha, COPE, Honorable G. Davis was subsequently replaced by Honorable Van Dijk from the same party, DA. On 5th May 2015, the subcommittee recommended to the Portfolio Committee that the following 12 candidates be shortlisted for the interview process. That is Mr. Dirazakhai Mauke, Mr. Kiabetu Mudimueng, Mr. Lance Rosfield, Mr. Lumkom Timde, Mr. Paris Mashile, Mr. Peter Hlapulusa, Mr. Peter Zimri, Mr. Sello Molefe, Mr. Tamsanga Denteni, Mr. Yangwayo Kuta, Ms. Butlenyana Mokhele, and Ms. Dimakato Kosha. On 2 June 2015, the subcommittee interviewed all the above-mentioned candidates, with the exception of Mr. Sello Molefe and Mr. Lance Rothschild, who withdrew from the process. The committee recommends to the House that the following 8 names be sent to the Minister in order to fill 5 vacancies in the ICASA Council. That is Ms. Butlenyana Mokhele, Advocate Makato Kosha, Mr. Lumkom Timde, Mr. Yangwayo Kuta, Mr. Tamsangan Tenteni, Mr. Peter Zimri, Mr. Kiabetu Mudimwe, and Mr. Peris Mashile. The committee notes the objection of Honorable Van Dijk from DA on the nominations of Mr. Lumkom Timde and Mr. Tamsangan Tenteni. I thank you, Chairperson.
There's been requests for declarations. I now invite the Democratic Alliance.
Thank you, Honourable Chairperson. The DA objects to 2 of the 8 names to be recommended to Minister Mutambi for appointment to the ICASA Council. The first is Mr. Lumkom Timde, who is openly and unapologetically supportive of the Media Appeals Tribunal, first proposed by the ANC back in 2007. We object to his appointment on the grounds that the ICASA needs councillors whose instincts are to promote media freedom and not to curtail it. The second candidate we object to is Mr. Tami Intenteni, who we believe is ineligible for the council on account of a criminal record. Reports in the public domain indicate that in 1998, the BMW that Mr. Intenteni was driving on the Ben Schoeman Highway in Gauteng crashed into a Volkswagen Passat from behind at high speed. 1 woman was killed and another 3 people were injured. The courts found Mr. Intenteni guilty of driving under the influence of alcohol and culpable homicide. It is understood that he was sentenced to at least 3 years in prison, which would explain the gap on his CV between 1998 and 2001. The ICASA Act states that a person may not be appointed to the council if they have been sentenced to a period of imprisonment exceeding 1 year without the option of a fine. It is therefore highly unlikely that Mr. Intenteni is eligible to serve on the ICASA Council. Honourable Chairperson, I raised this matter with the portfolio chairperson, the chairperson of the Communications Portfolio Committee, over 1 week ago. She told me yesterday that Mr. Intenteni had been vetted by the State Security Agency and that no trace of a criminal record could be found. This is difficult to believe given reports in the public domain, as well as Mr. Intenteni's own admission in this week's Sunday Times that he did in fact commit this crime. The DA cannot support Mr. Intenteni's appointment until we have answers to all the questions relating to his criminal record. I thank you.
Are there any further declarations? The EFF.
Thanks, Honourable Chairperson. The EFF as well wishes to object to some of these names, but fundamentally we want to register that there has to be a process of strengthening this institution to really reflect the Chapter 9 institution that the independent regulator is called for by the Constitution. Until such an amendment is there, it's going to be very difficult ever to think about an independent ICASA board, and we are seeing that there is a crisis of the ministerial interference, particularly the Minister of Communications in the state institutions like the SABC, but also this one stands the similar challenges that we are seeing being demonstrated in the department with regards to the SABC. We are also, the complied list of candidates presented by the PC on communications in March this year and the process that was followed to select candidates to fill vacancies in the Council of ICASA leaves a bitter taste, as when 4 council members were dismissed by the Minister of Communication without a clear explanation and before they were they completed their duties. The candidates list, which had names of contravening figures, some accused of soliciting sexual favors from employees and some with cases of culpable homicide, drunk driving, and other irresponsible behavior, was a clear indication this exercise was not to appoint a reliable counsel but consolidate a collection of potential lapdogs. So again, these appointments reflect not a proper engagement on the part of the committee independently, but an imposition, as it always happens in this committee with all of its work, of Luthuli House candidates. So the EFF objects.
Are there any further declarations? May I ask those parties who want to make declarations just to move to the waiting bench to save us time, please?
Thank you, Honourable House Chairperson. Honourable Chairperson and members of this Honourable House, the Independent Communications Authority of South Africa has not performed very well since it has been placed under the new Communications Department, a move which has led to diminished independence as a Chapter 9 institution and severely underfunded in resources. The lacuna which we had been created in the council when Minister Matumbo gave 4 councillors their marching orders last year has, in our view, severely compromised the effectiveness of the council. The NFP wishes to raise its concern about the lengthy delay in filling vacancies. 4 of the vacancies have been left unattended since September 2014. We suggest that in time to review the prescribed appointment procedure so as to accelerate the filling of any unplanned and unforeseen vacancies that may arise from time to time. We support the inclusion of all candidates shortlisted with the exception of Mr. Lumko Mtimde and Mr. Mtenteni. The NFP notes that of the 8 candidates shortlisted, only 2 are women. We would have hoped that the shortlist would have been more reflective of South Africa's gender demographics. I thank you.
Are there any further declarations? There being no further declarations, honourable members, the question before the House is that the following list of candidates be submitted to the Minister of Communications for consideration for appointment as councillors to ICASA. Ms. Botlenyana Mkhele, Advocate Dimakatso Kocha, Mr. Lumko Mtinde, Mr. Tamsanka Tenteni, Mr. Yengwayo Kuta, Mr. Peter Zimri, Mr. Kaibechwa Modimweng, and Mr. Peres Mashile. Are there any objections? There are objections, so I'll put the question. Those in favor will say aye, and those against will say no. I think the ayes have it.
Honourable Chair, we call for a division.
Honourable Chief Whip of the Opposition, did you rise for the same thing? Okay. Honourable members, a division having been called for, the bells will be rung for 5 minutes.
Now, back to South African matters of business. Parliament yet on alleged genocide. South Africa will take into the matter. The government has until Thursday to explain to the High Court. Al-Bashir. Boyani, this will be something that the opposition will be all over in Parliament today, I would think.
Yes, Eben, as you've rightly pointed out, this snap debate has been called at the
request of opposition parties. But the point that I want to make is that you'll recall last week in the National Council of Provinces, members of the DA, one of Parliament decision is the National Assembly of the ANC pointed out
parliamentary of a high court by the now. Back to South African matters of business. Parliament national requested that to you, Vuyani,
of opposition that is on Thursday,
this afternoon,
to put it to be there.
Set to South Africa this afternoon in Parliament. That is Vuyani Green giving us a little heads up ahead of this snap debate that's set in Parliament today with the controversy around the visit of President Umar Al-Bashir here to South Africa. Now, President Umar Al-Bashir here to South Africa. Now,
it is not the country we deserve and demand. With the
SABC. Just then your let's check.
Parliament
to undermine the
MPs Parliament.
As you can imagine, chaos in Parliament was pretty much all over social media overnight and this morning. All the utterings, your views.
Order, honourable members. Honourable members, we are aware that the division having been called, but there has been discussions amongst the chief whips, and I now recognise the chief whip of the majority party.
Honourable House Chair, we move the postponement of this item and we'll bring it back when it is been dealt with.
Yes. The item will thus be dealt with once it has been processed by the different political parties. Order, honourable members. Honourable members, we will now take orders 6 to 13 together as they appear on the order paper. These are the reports of the Committee on Public Accounts. Order, honourable members. I now call upon the Honourable Gordy.
Thank you.
Order, honourable members.
Thank you, Honourable House Chair, comrades and honourable members.
Order, honourable members.
I stand to present on behalf of the Standing Committee on Public Accounts its first to eighth reports, which comprise 4 unauthorized expenditure reports and 4 annual reports. Let me start, Honourable Chair, by thanking members of the committee for their diligence and solidarity. We have thus far maintained the committee's tradition of working as a team, never taking our eyes off the ball. As the protector of the public purse, we have a collective national responsibility to ensure compliance with the PFMA and Treasury regulations in the main. We call upon portfolio committees to close ranks with us to work collaboratively in ensuring full accountability by the executive to Parliament and to our people. We also want to extend our appreciation to the committee staff for the work they do to keep us going. Unauthorized expenditure is when expenditure occurs beyond the budget allocation. The House deals with unauthorized expenditure as per the provisions of sections 34 and 38 of the PFMA. When unauthorized expenditure is incurred, the affected departments write a detailed explanation to National Treasury, which in turn sends an explanatory note to SCOPA with its recommendations. SCOPA then calls National Treasury and the affected departments to appear before it for thorough discussions. It is only then that we prepare a report for this House to adopt. So the reports in front of you, comrades and honourable members, are a product of that thorough process. We are putting before this House for approval of the unauthorized expenditure of the Presidency, the Department of Social Development, Department of Trade and Industry, and the Department of Women, Children and People with Disabilities as a direct charge against the
Honourable
National Revenue Fund.
Honourable Gordy, will you just take your seat? Honourable members, there's too much noise in the House, and there's members sitting in the passages. Will you take up your allocated seats, please? Thank you. Continue, Honourable Member.
Chair, I thought I had 10 minutes. Is this 10 minutes? Okay, all right. Having said that, SCOPA would like to stress that departments must stick to their budget allocations, manage expenditure prudently. There is no money lying around to bail them out. They must do more with little, cut down on non-essentials, prevent fruitless and wasteful expenditure as well as regular expenditure. Chair, comrades and honourable members, we also present our reports on the 2013-14 annual reports of the Department of Defence, International Relations and Cooperation, Military Veterans and the Property Management Trading Entity of the Department of Public Works. On DERCO, there are issues with supply chain management, human resource and IT. We are particularly appalled by the mismanagement of the African Renaissance Fund, our financial instrument of Pan-African solidarity. The Director General is weak on consequence management. We call on the Minister to ensure that the DG does his work of taking firm action against officials who do not adhere to the prescripts of the law. Although the Department of Defence has a qualification due to intangible asset management, we're impressed by the attitude of the Secretary for Defence. We hope the department can for the first time get an unqualified audit opinion. We appreciate the establishment of the Internal Audit Unit, the Audit Committee, and the acquisition of a building to house the Internal Audit Unit. If Defense can get it right, surely there can be no excuse for other departments. The committee wants the amounts used for consultants and outsourcing to be reduced instead of going up. 3.3 billion rands is a lot of money. The property management trading entity, even though it has only a qualified audit opinion, has serious issues that require urgent attention. The issues of lease management, accruals, and investigations need speedy resolution. The Department of Military Veterans is in a sorry state. With a disclaimer of opinion, we are calling on the department to submit a turnaround strategy within 60 days from today to address the root causes of non-compliance, weak internal controls, instances of misconduct, as well as action taken. The NDP calls for the building of a capable state. Every public servant must answer to the question of what their contribution is in this regard. The executive have responsibilities in terms of the PFMA. They also must ensure that there is leadership stability in departments so that the correct culture of compliance with laws and regulations can be built and sustained. Honorable Chair, on behalf of the committee, I present these reports to the House for adoption. I thank you.
Honourable members, there's been a request for declarations. I now recognize the Democratic Alliance.
Honourable Chair, the DA supports 6 of the 8 reports. 2 we cannot support. It is inconceivable that 37.4 million rand of trade and industry unauthorised expenditure, can simply be written off. Some on the basis that the recovery of money would cause undue hardship to an ex-employee who owes that money. We are also being asked to write off other monies owed by ex-employees because it's uneconomical to recover these. So the message to state employees is that you can take the money that you are not entitled to, and you will not be forced to repay the money as long as it's not too much. Where are the consequences that the ANC keeps pontificating about? Then, Honourable Chair, we have the presidency. Oh, babo. I-President Zuma ufika la ekhaya. Uyenza ama-joke. Uyahleka. Oh, uthi lendlo yakhe eyakwe nemali yabantu bethu ayikho inkinga khona. Ayikho. Kule sonto edlulile lapha ne-Great Town. Nomngani wakhe uMavundla kade bevula imall laphana uyasichazela khona ukuthi uzowakhe imall eyakhe eNkandla kodwa uyaphuthuma ukuthi angayinayo imali mina kuyithenga impahla kulelo store. Hawu ucabanga ukuthi siyislima yini? Kampela abantu bethu bahlakaniphile. Bayabona lento ukuthi uyadlala ngathi. Bazobona kampela ukuthi imosa imali yethu. Honourable Chair, Parliament is being asked to write off 45.5 million of unauthorised expenditure from the presidency. Some of that relates to the president's mediation attempts in Zimbabwe. And we all know how that turned out. Just ask the millions of Zimbabweans who go hungry every day. That money was well spent. Clearly, President Zuma enjoys all the benefits of freedom and opportunity, but it is surely at the expense of our people who, by this write-off of unauthorised expenditure, are being robbed of their freedom and opportunity to be able to find a job and live in dignity. Madam Speaker, there is no fairness
Honourable Member, your time has now expired.
Unauthorised expenditure. The Democratic Alliance ngeke support lokho.
The EFF.
The EFF objects to this report with the contempt it deserves and will not support its recommendations to condone unauthorized expenditure to be paid by taxpayers' money. You are asking us to condone kleptocratic culture, which basically promotes gluttony in many instances. We cannot be asked to come here and condone the waste of 100 million rands by President Zuma and his ministers. Parliament is not the rubber stamp of the ANC. This has happened under the watch of many opposition parties since 1921, since 1994, including under the DA, who pretend to be holding government accountable. The EFF is not going to be the party, is not going to be party to this criminal conduct by the ANC. You should be ashamed for the audacity to request Parliament to condone this waste. The Constitution requires National Treasury to ensure that there are adequate expenditure controls in government. Minister Nhlanhla Nene and his predecessors have failed with flying colors in ensuring that government has adequate internal control measures in place. By your own admission, National Treasury says government has no system in place to ensure that the department doesn't overspend on its budget. Minister Nhlanhla Nene comes to stand here every year to dish out money for his ANC comrades to just eat. How can you, after 21 years in government, not have adequate control system in place unless it is not in your interest to have such systems in place? By doing nothing, National Treasury is concluding with these departments to allow their ANC deployees to steal taxpayers' money without any fear of accountability. To place the burden on taxpayers' money when they contribute most towards tax revenue, face sickening electricity tariffs, e-tolls, and increasing cost is a living criminal. SCOPA is the only committee we expect not to function in accordance with the instructions of Gwede Mantashe, but it has failed the public. It is obvious that the chairperson is too comfortable and too close to Lutuli House. We are told there are even money bags circulating in his home. He has overstayed his welcome. It is time for the EFF to chair that committee because we will make sure that President Jacob Zuma pays back the money. The committee has condoned unauthorized expenditure in millions without any criminal or disciplinary measures instituted against those who have wasted taxpayers' funds. No money is recovered. With 100 million rands, we would have built 1,000 decent houses, sent about 500 students to university for 3-year full degrees paid, including accommodation and food, or employ additional 300 grade 1 nurses for rural clinic and hospitals in the current budgetary constraints. This is a lot of money. Unauthorized expenditure in the presidency could have been prevented. But President Zuma and his family think that government money is their personal purse, like the chickens and the kettles in their kraal. We'll never support this, and we make yet another demand that you must pay back the money.
The IFP.
Thank you very much, Honourable Chairperson. The IFP will be supporting 7 out of the 8 reports. And having gone through the process in the committee of dealing with these matters, we are in a comfortable position to say that the committee has done its work diligently, except on the issue of the presidency. Because if we do not have consequences and we do not hold people accountable, this kind of behavior is going to continue. And the fact that up to now there isn't a portfolio committee to oversee the work of the presidency has landed us in this mess, whereby 2 events for the national orders are held in 1 year, and all sorts of other junkets being taken across the world, expeditions and excursions and visits and so on, and it's the taxpayer that must fund all of this. Secondly, the failure of the committee in this regard to have the details of the legal costs which the presidency is involved in presented to the committee is a major indictment when we demanded from all the other departments that they present to us line items in terms of how much had been spent on what and so on and so forth. When it comes to the presidency, there's this protection and it's being placed in a cocoon whereby nobody can be able to touch it. Now, on that basis, we cannot possibly, in the collective interest of saving the taxpayers' money, endorse that the unauthorized expenditure of the presidency be endorsed by the House. So there does need to be stronger accountability and oversight on the presidency to ensure that the monies that are spent in accordance with the annual performance plans. They are spent in accordance with the programs which the presidency has presented. But if they don't present them to anybody, how can we then possibly hold them accountable and expect that at the very end then we'll do corrective action? Secondly, I want to applaud the intervention of the committee in ensuring that we do not punish the Department of Women, because what had happened was that National Treasury called on us to deduct the unauthorized expenditure from the current budget, and we as a committee arrived at a conclusion that it would be unfair for us to do that, and I'm glad that we arrived at that working conclusion, because it was the previous minister who ran this department to the ground, and it is now we have to now resurrect it and resuscitate it to ensure that it is able to move forward. I want to say that albeit all the other challenges that may be placed over SCOPA, the committee is well on track in cleaning sweep the mess that is in government departments, and we will hold people accountable because we want to make sure that consequences are followed through. People who are guilty of transgressions and dereliction of duty must be punished. It can't go on as business as usual when the masses of our people find themselves in poverty every day, and there are people
Honourable Member, your time is now
wasting
expired.
the money of our people without any consequences. So we will walk the talk which we are talking. Thank you.
Are there any further declarations? The ANC?
Thank you, Chairperson. Honourable Lees, I was really disappointed with the way that you were dramatizing the whole thing. The unauthorized expenditure from the presidency of 2008-2009 comprises of the following economic classifications. 2.73 million was incurred from national orders, which was brought forward with the result that it had to be funded from a financial year in which it was not initially budgeted for. Most of the litigations were because, and the monies that were incurred, it was because nobody could predict the time and the length of those legal fees. But Chairperson, I want to emphasize the annual reports and what we have agreed on as the ANC. We support all the reports that have been presented by the chairperson here. ANC in its January 8th celebrations last year emphasized to deal with and root out corruption through the President Jacob Zuma. We are committed as a committee to deal with corruption. And as a committee, I think if anybody is going through our processes, you can all tell that we are indeed committed to protect the fiscus of the country. PFMA was passed 15 years ago, and as we celebrate it, we have to make sure that all of us are committed to make sure that we comply with all that is said in the PFMA and the Treasury regulations. However, we do have officials who are not committed in doing their work. Most of departments have actually improved from disclaimers to qualified reports because of the work that we are doing as SCOPA. Most of departments come to Parliament and they make commitments through their strategic plans. And through those strategic plans, they set out specific goals that they have to achieve. Most of the departments have achieved the specific targets, but others are not, because you find that most of the officials are not adhering to the Treasury regulations. And the problem that we find in most of the departments that we are dealing with today is that you find that one official has defrauded state from one department, and they are being recycled from one department to the other. And as a result, there is no consequences. And we are saying as SCOPA, especially as the ANC members, that we are going to make sure that those officials are taken care of seriously. That we are going to work with Public Service Commission to make sure that we name and shame all these officials. There are other officials who are also
Honourable
doing
Member, your
business
time is now
with
expired.
the state, and we are saying as SCOPA that we'll make sure that we root out corruption. Thank you.
Thank you, Honourable Member. Order, Honourable Members. I now recognise the Honourable Chief Whip of the Majority Party.
Honourable House Chair, I move that the reports be adopted.
The motion is that the reports be adopted. Are there any objections? There are objections. I now put the question. Those in favour will say aye. And those against will say no. I think the ayes have it.
Honourable Chair, we are calling for a division on unauthorised expenditure.
A division having been called for, the bells will be rung for 5 minutes.
Honourable Chairperson, I think during the declaration, some of the speakers indicated that they will be supporting some of the orders and not the others. I don't know how you're going to deal with that, because now you're putting all the reports together for voting. Thanks.
House Chair, the Democratic Alliance is opposed to only 6 and 8. So if we go ahead with the EFF suggestion, we're going to have to divide on every single report now.
Chairperson, Honorable Chair, the 5 minutes is finished. Can you please vote?
Please be patient.
No, but we can't be held at ransom.
No, there's a clock here in front.
No,
We're following the clock.
We're checking on our clock as well. The 5 minutes is finished.
No, order, honourable members. Order.
We can't be held at ransom by the
Order, honourable members. Just relax. Just relax.
Can you please vote?
Order, honourable members, will you take up your allocated seats? Honourable members, just after the Honourable Ndlozi called for the division, the Honourable Singh raised a point of order, and it is sustained, is correct. While the debate can be dealt as one, we'll have to deal with each of the reports separately in terms of the question. So we'll put each of the reports, and then we'll take a decision on them. The first report that I want to put to the House is the consideration of the first report of the Committee on Public Accounts on unauthorized expenditure of the Presidency. I now recognize the Chief Whip of the Majority Party.
Honourable House Chair, I move that this report be adopted.
The motion is that the report be adopted. Are there any objections? There are objections. I put the question. Those in favour will say aye. And those against will say no. I think the ayes have it.
A presidency, the EFF calls the division on the unauthorized expenditure in the presidency.
A division have been called for. The bells will be rung for 30 seconds. Order, honourable members. Order. I would like to remind members that they may only vote from the allocated seats. When requested to do so, members must simply indicate their vote by pressing the appropriate button below the yes, no, or abstain signs. If a member inadvertently presses the wrong button, the member may thereafter press the correct button. The last button pressed will be recorded as the member's vote when the voting session is closed. The question before the House is that the report of the Standing Committee on Public Accounts on unauthorized expenditure of the Presidency be adopted. Are all members in the allocated seats? Voting will now commence. Those in favour of the report be adopted should press the yes button, and those against should press the no button. Those wishing to abstain should press the abstain button. Have all members voted? The voting session is now closed. Honourable members, the result of the division is as follows. Those in favour 191, those against 105, and there's no abstentions. The report is thus adopted. Honourable members, I now put the second report of the Standing Committee on Public Accounts on unauthorised expenditure of the Department of Social Development. I now recognise the Honourable, the Chief Whip of the Majority Party.
House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? There is an objection. I will thus put the question. Those in favour will say aye. And those against will say no. I think the ayes have it.
The EFF calls for a division.
A division having been called for, the bells will be rung for 30 seconds. Order, honourable members. I would like to remind members that they may only vote from their allocated seats. The question before the House is that the report of the Standing Committee on Public Accounts on unauthorised expenditure of the Department of Social Development be agreed to. Are all members in their allocated seats? Voting will now commence. Those in favour of the report be adopted should press the yes button. Those against should press the no button. Those wishing to abstain should press the abstain button. Have all members voted? The voting session is now closed. Honourable members, the outcome of the division is as follows. Those in favour 283, those against 15, and there's one abstention. The motion is thus agreed to. Order, honourable members. I now put to you the third report of the Committee on Public Accounts on unauthorised expenditure in the Department of Trade and Industry. I now recognise the Honourable, the Chief Whip of the Majority Party.
Honourable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? There are objections. I put the question. Those in favour will say aye. And those against will say no. I think the ayes have it.
The EFF calls for a division.
A division having been called for, the bells will be rung for 30 seconds. Order, honourable members, you are reminded that you may only vote from houses that the report of the Standing Committee on Public Accounts on unauthorised agreed to. Are all members? Honourable members, the outcome of the division is as follows. Those in favour 211, those against 91, and there are no abstentions. The motion is thus agreed to. Honourable members, I now put to you the consideration of the fourth report of the Committee on Public Accounts on unauthorised expenditure of the Department of Women, Children and People with Disabilities. I now recognise the Honourable, the Chief Whip of the Majority Party.
Honourable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? I put the question. Those in favour will say aye. And those against will say no. I think the ayes have it.
The EFF calls for a division.
A division having been called for, the bells will be rung for 30 seconds. Honourable members, you are reminded that you may only vote from your allocated seat. The question before the House is that the fourth report of the Committee of Public Accounts on unauthorised expenditure of the Department of Women, Children and People with Disabilities be agreed to. Are all members in their allocated seats? Voting will now commence. Those in favour of the report should press the yes button. And those against should press the no button. Those wishing to abstain should press the abstain button. Have all members voted? The voting session is now closed. Honourable members, the outcome of the division is as follows. Those in favour 288, those against no 14, and there are no abstentions. The report is thus agreed to. Honourable members, I now put to you the consideration of the fifth report of the Committee on Public Accounts on the report of the Auditor General on the annual report and financial statements of the Department of Defence for the 2013-2014 financial year. I now recognize the Honourable the Chief Whip of the Majority Party.
Honourable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? I put the question. Those in favour will say aye. And those against will say no. I think the ayes have it.
The EFF calls for a division.
A division having been called for, the bells will be rung for 30 seconds. Honourable members, order. The question before the House is that the report of the Committee on Public Accounts on the report of the Auditor General on annual report and financial statements of the Department of Defence for the 2013-14 financial year be agreed to. Are all members in their allocated seats? Voting will now commence. Those in favour of the report should press the yes button. Those in favour of the report should press the yes button. Those against the report should press the no button. And those wishing to abstain should press the abstain button. Have all members voted? The voting session is now closed. Honourable members, the outcome of the division is as follows. Those in favour 286, those against 15, and there are no abstentions. The motion is thus agreed to. Honourable members, I now put to you the consideration of the sixth report of the Committee on Public Accounts on the report of the Auditor General on annual report and financial statements of the Department of International Relations and Cooperation for the 2013-2014 financial year. I now recognize the Honourable the Chief Whip of the Majority Party.
Honourable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? there is an objection, I put the question. Those in favor will say aye. And those against will say no. I think the ayes have it.
The EFF calls for a division,
A division
on
having
unauthorized
been called for,
expenditure.
the bells will be rung for 30 seconds. Order, honourable members, will you please take up your seats? The question before the House is that the report of the Standing Committee on Public Accounts on the report of the Auditor General on annual report and financial statements of the Department of International Relations and Cooperation for the 2013-2014 financial year be agreed to. Are all members in their allocated seats? Voting will now commence. Those in favor of the report should press the yes button. And those against, the no button. And those wishing to abstain should press the abstain button. Have all members voted? The voting session is now closed. Honourable members, the outcome of the division is as follows. Those in favor 288, those against 12, and there are no abstentions. The motion is accordingly agreed to. Honourable members, I put to you the consideration of the 7th report of the Committee on Public Accounts on the report of the Auditor General. Order, honourable members, on the annual report and financial statements of the Department of Military Veterans for the 2013 financial year. I now recognize the Honourable, the Chief Whip of the Majority Party.
Honourable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? There are objections. I put the question. Those in favour will say aye. And those against will say no. I think the ayes have it.
The EFF calls for a division.
A division having been called for, the bells will be rung for 30 seconds. Order, honourable members. The question before the House is that the report of the Standing Committee on Public Accounts on the report of the Auditor General on the annual report and financial statements of the Department of Military Veterans for the 2013-2014 financial year be agreed to. Are all members in their allocated seats? Voting will commence. Those in favour of the report should press the yes button. Those against should press the no button. And those wishing to abstain should press the abstain button. Have all members voted? The voting session is now closed. Honourable members, the outcome of the division is as follows. Those in favour 291, those against 12, and there is one abstention. The motion is thus agreed to. Honourable members, I now put to you the consideration of the 8th report of the Committee on Public Accounts on the report of the Auditor General on the annual report and financial statements of the Property Management Trading Entity for the 2013-2014 financial year. I recognize the Chief Whip of the Majority Party.
Honourable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? There are objections. I put the question. Those in favour will say aye. And those against should say no. I think the ayes have it.
Chairperson, The EFF calls for a division.
A division having been called for, the bells will be run for 30 seconds. Order, honourable members. Order. The question before the House is that the 8th report of the Committee on Public Accounts on the report of the Auditor General on the annual report and financial statements of the Property Management Trading Entity for the 2013-2014 financial year be agreed to. Voting will now commence. Those in favour of the report should press the yes button, and those against should press the no button. Those wishing to abstain should press the abstain button. Have all members voted? The voting session is now closed. Honourable members, the outcome of the division is as follows. Those in favour 288, those against 12, and there is one abstention. The motion is thus agreed to. Honourable members, the Secretary will read the 14th and 15th orders.
Consideration of report of Portfolio Committee on Higher Education and Training on 2013-2014 annual report of National Skills Fund and National Skills Authority. Consideration of report of Portfolio Committee on Higher Education and Training on 2013-2014 annual report of Local Government Sector Education and Training Authority and Services Sector Education and Training Authority.
I now recognize the chairperson of the committee, the Honourable Posa, who will introduce the reports.
Thank you, Honourable Chair. Honourable Chair, I rise to table the NSF and the NSA reports on behalf of the committee. On the 29th of October 2014, the Portfolio Committee on Higher Education and Training met with the NSF and NSA entities to assess their financial and non-financial performance for the 2013-14 financial year. Now, the findings were as follows. As per Section 27 of Skills Development Act of 1998, the mandate of the Skills Fund is find identified projects in the National Skills Development Strategy as national priorities, fund projects related to the achievement of the purpose of the Act. The report acknowledges that progress has been made with regards to the entity in the last financial year. Concerns have been raised that relate to several issues such as the high vacancy rate, which could have an impact on projects monitoring and evaluation. Inaccuracies that were found in the annual report 2013-14 that relate to its financial statements, as well as unreliable and vague targets and underachievement of targets for the 2013-14 period. Concerns were raised about the inadequate record and information management system for the financial and performance reporting. Strides have been achieved in funding the national skills development priorities as identified in the National Skills Development Strategy 3, National Growth Path, IPEP, and MTSF 2009 to 2014. Funding of the infrastructure development for the post-school education and training institutions to expand access and success to education and training was commended, as well as unspent CETA surpluses funding was transferred to the NSF to be used on other priorities. Therefore, it was recommended that delinking of NSF from the Department of Higher Education and Training should be accelerated. Filling vacant posts should be prioritized. Clear performance indicators would be developed to monitor the performance of the funded learners. On the mandate of the National Skills Authority, the committee found that the mandate of the National Skills Authority is to review skills development legislative framework, development framework to mobilize business, government, labor, and community to take ownership of the National Skills Development Strategy, support the development of a post-school education and training system that encourages society to build a developmental state and encourage research, development of an innovation that promote beneficiation and business enterprise. Its main purpose is to advise the minister and liaise with sector education and training authorities and the National Skills Development Strategy. Concerns were raised about inadequate financial reporting, though it received money from the NSF and the Department of Higher Education and Training. Commendable is its continued advice to the minister with regards to skills development issues, and the SETA's recommendation was made to increase its research capacity. Honorable Chair, I table the report for consideration by the House.
Thank you very much, Honorable Chairperson. I now recognize the Honorable Chief Whip of the Majority Party.
Honorable House Chair.
Chairperson of the Higher Education Committee can then take her seat. Thank you very much, Chair. Honorable Chief Whip of the Majority Party.
Honorable House Chair, I move that the report be adopted.
Declarations having been received, I now recognize the DA.
Chairperson, the DA objects to the second of these two reports because we don't. The hubris is palpable. In its childhood, the SETA develops a strategic plan, which is hugely ambitious and looks good on paper. In its adolescence, the SETA, however, goes off the rails, like a teenager who gets hooked on drugs. But these are not chemical drugs, they are the drugs of money and patronage. People start stealing. They fail to meet their targets. They under or overspend, and they appoint the wrong people into jobs they can't do. Things sink into the familiar mire of ANC mismanagement and disaster. An entire layer of rent-seeking parasites grows upon the fat of the SETA, pretending to offer educational opportunities, but in fact simply making money. The Department of Higher Education, of course, gets to the point where it can no longer ignore the failures of the SETA and puts it into rehab, or as is more commonly known, under administration. An administrator comes in who develops that wonderful thing, a turnaround strategy. SETA, perhaps the most unsuccessful and incompetent in the country. It is now under administration, and it is doubtful that when the period of administration ends, it will be fixed. The committee has made stringent recommendations to the department, but will these recommendations be taken seriously? Or will this important SETA be allowed to sink further into the mud of incompetence that characterizes local government in general? We believe SETAs have no sustainable future, and the funds again should be taken away from the rent-seeking parasites and given to students for their education. Thank you.
DFF.
Honorable House Chair, when the new regime on the skills for South Africans was re-engineered, there were many hopes, in particular around the earlier failures when the